Gentlemen, I apologize for the delay, but one of the attorneys is running a couple minutes late. I wanted to start with that application, which is Long Neck Point. And the reason for my adjusting the agenda this morning, or this evening, is because I'd like staff to be able to leave early and not hang out for matters that they're not here for. So I want to get those matters done first. I wonder if I should start with Zevnik.
That's okay. We could do that.
I mean, why not?
Why not? Because that also requires staff.
That right?
Right, so let's just do
You
that.
ready for Zevnik?
Okay,
Because maybe we can do that first.
yeah.
But hold on, let me.
Hold on, we gotta open and do some things.
So once again, okay, first of all, welcome. This is a regularly scheduled Zoning Board of Appeals meeting on May the 24th. It's 7:30, we're in room 206. We're going to start first by reopening and immediately continuing the matter of calendar number 4-223, application of Wilder Gleason for the property known as 3 Haskell Lane. That will be continued until June 14th, okay? Okay. So we are going to jump around on the agenda a little bit tonight. That's only because I want to accommodate staff. So thank you, I appreciate your patience and cooperation. So with that, I'm jumping to calendar number 7-2023, the application of Wilder Gleason on behalf of Daniel and Lindsay Zevnik for the property known as 102 5 Mile River Road. All right, Mr. Gleason, the floor is yours.
Yes.
Wilder, if you're going to use PowerPoint, which it looks like you may be,
Yes.
we're going to need to move that TV one way or
Okay,
the other.
I'm blocking this.
Either you're moving or the TV is.
Okay, so let me just get this.
And could you
Do you have
state
a
your...
microphone on the
Yes, yep, it's all connected. Could you state your name, your first and last name for the record?
My name is Wilder Gleason with Gleason and Associates, and I represent Daniel and Lindsay Zevnik, who are with us tonight. They're in the audience. They just arrived, and hopefully they'll be a
Well,
signal.
that's good for me, but John, you
Can you
okay?
guys hear? Are you okay?
Yeah, you're good? Okay, we're good. Thanks,
Same
Jeremy.
version of the package.
Thanks, Chairman. So, let me go up to the beginning. I'm asking you to renew a variance that you granted in 2021. And it's the same variance, same plans, nothing's changed. The only thing that happened is, in the midst of the pandemic, you granted this variance back in 2021. And because of the difficulty in getting contractors and everything else, my client was then able to commence construction within the 6-month deadline to implement the variance. So we'd like you to allow him to do the same thing you permitted 2 years ago and build the same additions that he proposed then.
So Wilder, just to be clear, what you're proposing this evening has not changed one iota from what we approved in 2021. Not one nail, not one screw, nothing.
Correct. And in fact, my presentation is basically the PowerPoint that I did last time, okay? And I won't go through it all, but I will go through it very quickly to refresh your recollection.
Okay, I'm going to ask very quickly.
Okay.
Because I'd like to hear from staff, and I apologize, keep referring to you guys
No.
as staff, but it's the short way there. I'd like to hear from them and why this,
Oh,
so you go ahead and do
okay.
your thing, but
So-
please make it quick.
Yep, all right, so This property was, the house was built in 1907. It's about 3,000 square feet in a little under 4/10 of an acre. It is, when we came to you last time, the setback was called out, and this, it had been determined there was a 90-foot front yard setback from the eastern edge of the property. The north is up here, east is over here. And this is a lot that doesn't touch 5 Mile River Road. You may recall that. So all it has is rear yard lines. Because in order to have a front yard, you have to have a portion of your property touch a street. No portion of this property, no lot line touches the street. In order to have a side lot line, it has to be a lot line that intersects a front lot line, and all other lot lines are rear lot lines. None of these lot lines intersects a street or is adjacent to a street. So we have rear lot lines and a rear yard setback all the way around. Nevertheless, the property had been interpreted to have a 90-foot setback, which is the additional 50 feet that's required when you have a narrow road. And that was what had historically been the basis of variances. There's a series of variances that were granted for this house over time from 1907. We came in, looked at it, and here's the house. This is the house, you're looking up the driveway, and that's 5 Mile River on the far side of that hill. This is the house looking from the south side. There's the garage. This is the driveway that leads to the garage. This is the driveway leading out to 5 Mile River with the Manelli residence and their fence next door. This is the rear of the house where the garage is, and that's the garage that exists now, and there's space above it, it's a kitchen. And the basic plan is to build over this garage another story, and to come out 10 feet this way from the garage. That's what the plan is that you approved previously. So we looked at revising the setbacks because the 90-foot setback didn't apply, and then the orange here that I've called out is the applicable setback of 25 feet rear yard for all of the house. And what that does is it takes a house that was nowhere in buildable area, and it puts over a half of it into the buildable area. And then what we're doing is we're seeking to add on to this a second story here. Half of it basically meets zoning regs, but the northern half here is in the setback, and so we need a variance for that. And we're asking for a slight footprint increase here. It's 103 square feet, which is the solid pink. That's 103 square feet. So the proposed setbacks, we are looking for a determination that 25-foot setback applies on, as shown here. And because we're in a R1/2 zone, the setback on the westerly side is 40 feet. You have to use the half-acre rear yard setback for that. So, a half, and I'm sorry, this is the 1 acre zone. So it's a 40-foot setback for a rear yard in a 1 acre zone. So these setbacks were blessed by you last time around, but it's not clear that that would be holding again, so I'm asking for you to make that same finding again. And what that does is it changes the nature of the variance, because now we're adding over existing non-conforming, that over half of it is located in the setbacks, and we're adding a little bit here. So this is building coverage on top of what's existing, and this is new building coverage. Okay?
Could I just ask, the board last time determined that appropriate setback was 25 feet?
Well, as shown on that map. So it's 25 feet from the west
Right.
and north property line, the east, north, and south property lines. And that it's 40 feet from the west property line.
And so what, they determined that there was a front lot?
No, it's not a front lot. There's no front
So
lot.
what was the basis for determining it was 25 feet?
Because in a R1/2 zone, the rear yard setback is 25 feet. And this portion of the property from here forward is in the R1/2 zone. And so we
So
have,
why is there even a question about that then?
because the zoning enforcement official there'd been a number of variances granted where the old setback was, this is what they determined was the setback by adding a front yard setback of 90 feet. And the reason they used 90 is it's a 40-foot front yard setback plus 50 feet because you have a narrow
No, I get that,
road.
but where did the 40 come from? I get the narrow that added the 50, where did the 40 come from originally?
I have no idea. I mean, all I know is this is what they've done for, since 1907, and they needed variances to the
I guess it's
history.
not fair that you're not getting the benefit of being a front yard, but you're adding the 50 yard, the 50.
Yeah, we're just getting hammered. And Dave Keating, who was the CEO at the time, agreed with my interpretation, but he wasn't going to vary, he wasn't going to just reverse what had been historically the process. So we came to you, you said, it's okay, these new zone lines are the applicable zone lines, and they're shown on this portion of your exhibit. And I'm just asking you to make that finding again. This is not a simple application, there's just a couple of pieces to it. So then, this is the analysis why we're not a rear lot, et cetera. It's all in the zoning regs. We have a letter from Jeff McDougall in 2001 that says, based on the research, this property is the same as it's existed since the 1940s. And the reason that applies is there's a regulation that says, it's 339, that says, for any lot created after 1960, the frontage of which is less than the minimum required, we add another 50 feet. Well, that doesn't apply because we predate 1960. So even if we did have frontage, which we don't, but there was sort of like a double whammy to it. So,
And Wilder, we see in the packet that there's neighbor support. Have any neighbors changed hands since it started?
all the letters you have are new letters from new neighbors. Same neighbors in many cases. I think there's one change.
Okay, so when were these, so I didn't even look at the dates.
They're
These are not in the
March
original
of
packet.
23.
Okay,
The letters of support, every neighbor who's
Good.
affected has signed off.
okay.
So, I believe that's right, Dan.
Yeah, there's neighbors that have
Yeah.
changed hands.
Yeah, so we've got, every neighbor currently has approved this and supports it. So, I'm not gonna bore you with the chain of title and the septic deed and all this other stuff that relates to that. One thing I do want you to know is the septic plan is located in the front yard. This is the garage, this is where the driveway swoops around to go into the garage, and that's where our septic is. Now, that happens to be buildable area, but it's not really available for us, which is our hardship. One of the grounds, okay? These are the same plans that you looked at last time. And I haven't changed anything, I just reused the slide. So, the yellow is new volume over existing, okay? There's 2 stories now. The red hatch is the roof line of the existing. And what we're proposing is add another story up here to get us another bedroom. We're pushing out the back 10 feet for the garage and a little bit more on the second floor, so we get a decent screen porch with a walkout balcony above. That's it. So this is new building footprint, new second floor building footprint, because we're expanding out a little bit. And this is existing, we're adding a second and third up here. So that's what's happening on that. Then, looking at it from the north side, this is north. So we're looking at the building, the additions going to our left. This is all new. This is existing roof line, this is the new building, okay? And this is looking at it from the garage side. As you're looking at it from the south side, the garage is being extended towards us, and there's initial construction up here, and that's the existing roof line on the existing house, okay? So the portion that really violates, or that we need the variance for, is this little corner here. And it's 103 square feet. And we have support. The application of the regulations, this is a really unusual lot. In 40 years, I've never seen a lot like this.
Can you give 30 seconds on why it's unusual?
Yeah. The revised setbacks make over half the existing residents compliant with setbacks, reducing nonconformities. Your change in the zone setbacks reduces nonconformities. Most of the new space is over the existing building footprint. The placement of the original residence close to the east and north property lines in 1907, before zoning regulations existed, you know, what do you do? Are you going to pick the house up and move it? No, there's been several variances previously that allowed expansions of this house. And now, so that allowed prior owners to invest without making changes. The septic system is a hardship. We can't build in the buildable area because of the septic system. And 103 square feet of non-compliant building footprint, less than half of the proposed screen porch is what's happening. And the lot itself is a very unusual lot. I'm honest, I don't recall any lot that is, usually you have a rear lot with a flag touching something.
Does the
And-
septic system need to be upgraded for the additional bedroom you're adding?
No, we're okay with that.
Okay,
So that's been vetted.
okay, good.
Okay. Okay. Are you good?
I'm good.
All right. May I ask, because I don't happen to recall, but was the then zoning enforcement officer, Mr. Keating, was he in attendance at the previous hearing in 2021? Was he here?
I don't recall, no, he wasn't, because, you know, I did it remotely
Okay.
from my third floor
It would
son's
appear
bedroom.
that the new zoning enforcement officer is here. Do you know why?
He's here, I think, more likely on the next application.
Well, let's find out. Does anybody in the audience like to be heard on this matter? Is that true, really? Okay, good. I was told that, never mind what I was told. Okay, so no one else has any other further comment? Fine.
I do have some questions. Yeah, I have a couple of questions, not comments, but questions.
Please come to the podium.
Here.
Sure. You're certainly allowed.
State your first and last name for the record as well.
Sure. Harvey Hammond, zoning enforcement officer. I looked at these plans and I try to, like you, understand, you know, all the history and everything that has to do with it. And I'm a little unclear on adding the second-story addition, not being an increase of the nonconformity, and also pushing the garage further towards the rest of the lot, also not increasing the nonconformity of this structure. Maybe you can address
Yeah,
that.
Darien has historically said that if you have an existing nonconformity, I think it's easier if we turn to the setbacks, the survey, not that one, sorry. This survey. So what happens is, this is a nonconformity here, but Darien takes the idea that the zoning setback extends over that roof line to here, and if you're going to increase the building envelope, you have to get a variance for that increase.
So are you asking for a variance?
So I'm asking a variance for that increase to allow that to occur.
And same for this portion, which
Right.
is a one-story.
That's a one-story, well, that's
Right, but
actually
it's
two
either
stories.
Two-story because of the garage, but
Because-
it appears like a one-story.
Yeah.
And it's just also non-conforming, but that's a new,
No, it's the same because it's all part of the same thing. Our closest portion is here. The eave is 11.1 feet, I think it is, I'll just see what it says
so
here.
the 103 square feet is this little square, which is brand new, right?
Right,
It's
that's
not-
brand new.
It doesn't exist, there's no footprint on it.
Right.
It's just brand new.
Right.
Okay.
And that's part of
I
it.
think we understand there's been.
No, I was just wondering.
Despite Wilder's creative argument that us improperly classifying the setbacks where they should be leads somehow to a reduction in nonconformance because we're saying it's now less onerous than it was, but that's just someone interpreted it wrong in the past. We are expanding the nonconformance here, and that's, I guess, the variance request, which there's testimony about the unique nature and the hardship, et cetera.
Right,
And,
okay.
and, so, yeah, I don't know.
That just clarifies what just where I was with the overall positioning of this.
And while I will question, I presume you, the board, agreed in their testimony about how this was the minimum adjustment necessary?
Oh, yeah, I mean, we went through that.
Okay,
Yeah.
okay.
I have no further questions.
Thank you. Thank you very much. Okay, then I think if there are any other questions, or there are no other questions from any other board members, then we're going to close this application. Okay, application closed. Okay, Ms. Kaufman has disappeared yet again.
Shall I go out and get them?
You know, I had Woody, are we on Saturday night tonight? I hope they started it, because I forgot to tell them. Ms. Kaufman?
Is that them?
Yeah. I'm Pete. Sorry, you guys. Sorry, everybody. Okay, we're going to move to application number 5-2023, the application of Jackie Kaufman on behalf of Leslie Gold for the property known as 200 Long Neck Point Road. Ms. Kaufman?
Thank you. I hear you were using this. Thank you, sir. Thank you. Just give me a moment to open this up. Sorry, it's stuck on the view. Oh, I'll leave it up like this. Okay. Moment. Okay. Good evening. My name is Jackie Kaufman. I'm an attorney with Carmody, Torrance, Sandak, and Hennessy in Stamford, Connecticut. It's very nice to see you. Thank you so much for making time for us tonight on this agenda and for adding us earlier. I'm here today on behalf of Dr. Leslie Gold, who's here with me. She owns 194 Long Neck Point Road. And we are here appealing the decision of the zoning enforcement officer to authorize a pool permit and accessory structures that were authorized by the Planning and Zoning Commission through a modified CAM application and associated other applications in December of 2022. And then the building permit was applied for very quickly thereafter and issued in January of 2022 in violation of a building line. And it goes over a building restriction line that dates back to the creation of this subdivision in the early 1980s. So here I have a map that just orients you to the property. This property here is the property owned by the Sewlers, represented by Attorney Gleason, and you don't see the pool here, but this is their property. This is 194 owned by my client. Just to give you an orientation. A little difficult to see. Let's see if I can zoom in here. This is a tricky map, but it shows you that the location of the approved pool improvements, which was modified in December of 2022, to these locations here. What you can see very faintly here is the building line restriction that's at issue right now. And so there is a portion of the improvements that are located in the restricted area, so to speak. This dates back, to, as I mentioned to you earlier, to the 1980s. This is a copy of the subdivision map, which is on file within the Darien Land Records. And you have copies of all of this extensive title background. But I think it just helps here to just review it one more time. Let's not open my email mysteriously. And again, so here's the Sewlers property, here's Dr. Gold's property, and you can see here that the building restriction line, which is highlighted in yellow, is consistent with the subdivision line that was created for these two lots up here. The reason why that's important is because when we go back to the variance application that predates the subdivision application by a little less than a year, it allowed this subdivision to occur with multiple variances that were varying the lot width, the lot size, and the building squares. Because this property was mostly developed at the time that the subdivision was created, it was designed in a manner that would accommodate the existing buildings. And the only way to do that was to actually issue variances to allow that. You have that information as well. And I think that's very critical to the reason that the building restriction line was there, because it was retroactively being applied to an existing development or compound or family estate at the time that was then subsequently divided into multiple properties. That was, that condition itself was, it doesn't say building line restriction shall be there, but the approved subdivision map, both the filed subdivision map and the approved subdivision map, which you also have, is identical to the subdivision map that was ultimately adopted a few months later and then subsequently recorded on the land records. Also, in the notes on this map, which are also very similar to the notes that are on the ZBA approval, these notes all make reference to different actions, including the ZBA approval, including that prior ZBA map, including restrictive covenants, including building line restrictions, and they reference you back to the Darien land records. So the inclusion of these notes as part of the approval process is very critical, because that means that the town now has public documents that it, with conditions and restrictions that can be enforced. I know that was a question of this board and also raised in the memorandum that was submitted earlier this week. Does the ZBA have, or does the zoning enforcement officer have the ability to enforce private restrictions? Well, why this also is a private restriction that's included in the deed history, as Attorney Gleason mentioned, as I also reference in my appeal paperwork, it also is it's a public document. It is part of a subdivision. And when it is part, the Connecticut Supreme Court has said that when you have conditions that are part of approvals, and very much specifically ZBA approvals, whether they are enumerated conditions or whether they are reflective within the record, that they are enforceable. Specifically, that case is, and I did have these I emailed these over to you, Woody, didn't have time to copy the case law before I came over here tonight, but just so that you all have it in your file and as part of your record. The case is called Entre v. Madison Zoning Board of Appeals from 2013, so not that old. So in this case, someone wanted to do a little bit of something to their house. It wasn't specifically enumerated in the conditions. They wanted to build a porch where they had to stay within a particular footprint. And the Zoning Board of Appeals ultimately denied them. But on appeal, the Supreme Court held that the conditions that were attached to the granting of the variance didn't need to be explicitly described in the enumerated conditions, but they could be construed by examining the language of the record in its totality, whether that was inclusive of a recorded map, of maps in the record, or testimony that was taken as part of the oral record, like we're having right now. And any accompanying plans and exhibits, the minutes, the transcript, and the record of decision. So ultimately what the court stated here, and I quote, is it makes more sense to treat a certificate of variance, which refers to conditions having been attached, like in a map, as a notice to all those searching the land records that further investigation should be undertaken by reviewing the administrative file. So the court reasoned that by its terms, the variance required a review of the administrative record to determine if, in this case, the deck complied with the underlying plans, and if they could enforce that the deck couldn't be built. So I think in the same vein here, a variance and subdivision approvals, these were granted and they're inexorably tied together. And all reference this building line. Back to the beginning, back to when the discussion of this development, this neighborhood, how it would be developed, how it would be maintained, and what would be appropriate. So under that same reasoning, the zoning enforcement officer had the same duty of care, or, you know, if you didn't know all of these things existed at the time. Although I will say that during that application in December of '22, on those records, very clearly, on the McCord records, it shows this building line. They weren't trying to hide the building line, but the building line was there. I don't see any evidence of discussion among the board members or the applicant as to, is this okay? Because when we look back at the restrictive covenant language, swimming pools are enumerated as a prohibited improvement in this area. And also just by viewing your own zoning regulations, even independent of that, if we were to say that this building line restriction prohibits any activity beyond that line, a swimming pool typically requires a building permit and is considered a permanent structure, and would also then be prospectively, or can be interpreted as prohibited here. But if you investigate this full record and you take it back to 1982, you see this line on public maps very easily, easy to achieve. And as you know, because you issue variances, oh, sir, go.
Well, so if I'm understanding your argument correctly, you're saying that a private restrictive deed line that inures to a specific parcel, but because it was publicly noticed and it's in public records that this line exists, that now the ZEO has authority to enforce it?
Yes.
Yes, that's what you're saying.
Yes, that is what I'm saying.
Well, then I'm understanding what you're saying.
And I think that it can also be applied in a few other ways when we think about this, that the enforcement of private agreements would be between any party. On a subdivision application, you might see a conservation easement. The conservation easement is between the town and between a private owner or a group of owners. It's still private, and it's still an agreement, but it's publicly noticed on a map, and there is an agreement there too. Also, what about a utility easements, CLMP easements, or other types of easements that sometimes will impact the reason why you issue that variance to begin with. It may contribute to the hardship. What I don't know, and I can't tell from this record, and unfortunately it's 40 years old now, is this building line restriction may have been critical to the hardship found that allowed the dimensions of these lots to be altered in a manner that became less than what was acceptable.
Okay, that's purely speculation, but I understand the comment.
But it is on the record, and it's referenced in multiple places throughout the record and on these land record maps. So I think that is a very critical point. We do believe that it is enforceable by the zoning enforcement officer as a result.
Can I just press you a couple of things?
Please.
One is there not a distinction between something like conservation easement that benefits the public more broadly, or a utility easement, and this, which is a restrictive declaration between two private parties that, by the very terms of the declaration itself, was specifically called out for the benefit of one specific parcel owner?
Certainly fact specific. I think that depending on the nature of the easement, I'm just
Right.
giving examples of other easements that may or may not benefit like one or more people, but that should be less relevant than why it is included
No,
on
that's
a
my next
document. And if
question.
it was just on a subdivision map
Understood. by
by itself without the variance, I don't know if it would be as strong.
Yes, I want to press you on that a little bit to understand better. So I don't think anybody's disputing that there are publicly recorded documents that reference either in words or in diagram this line. But I want to understand, but the critical thing is this subdivision map. You're saying that this document on its own, recorded in the public documents, stands for the proposition that it is public and therefore enforceable by us, right? I think what you said was, these are public documents that can be enforced.
That is
right?
correct.
So I just want to understand more broadly that concept. who created this document, I guess? It was by one of the private parties, surveyors or architects or something, right?
By the subdivider,
Right, okay.
by the original subdivider, yes.
Which was a private, employed by a private, one of the parties who owned the properties.
Yes.
Is that right? Now, what if that document contained an error in it? Would it still be enforceable? Like, are we bound by it just because it's publicly recorded?
If an error can be demonstrated, then that's called the Scrivener's error, and usually can be corrected through corrective deeds and documents, affidavits, and revised quitclaim deeds. But here, I can tell you it's here. It's a great question. I realize you're playing devil's advocate, but we also see we see it in the notes, and we also see this map
Well, so what
referenced
do
in
we
the
see in the
deeds.
notes? The notes
Oh,
just
sure.
say, I presume the notes say there is a, pursuant to a restrictive declaration, there's an area where you can't build various things in. Is that what it says?
So I can tell you here, all of into the. Specifically, they reference town actions, the companion land use approvals that influenced this approval for subdivision, recordings and covenants, including the PZC subdivision 949, the underlying approval that accompanies this map, CAM application 26 with conditions recorded, approved in 1982, Zoning Board of Appeals approval 81, 1982 with conditions 1982, variance recorded, the variance recording at 468, 499. The Planning and Zoning Commission Coastal Site Plan Review, companion review, and note number 3, declaration of restrictive covenants in open space documents, in note number 5.
So did any of those, as far as you can find, those public approvals and the documents that went along with them reference as a condition the establishing of this restrictive building area?
The declaration of restrictive covenants in an open space reference additional things that you see in this map. The building restriction line, is that called out as its own specific condition in the other approvals? No, it's not. It's captured on this map, and what we know from the court and what we know just from practice is that that's not always the case, that notes that are included and thereby accepted as reviewed and approved don't always show up as an enumerated condition. But in the title documents to these properties, there is reference to the building line restriction. And that is specifically,
Yeah, no, I'm not
right?
disputing that. There isn't a
Okay.
public document that would be referenced in title, but this is a critical point here. So go back, sorry, because I think you glossed over it a little bit. The public approval process
Mm-hmm.
of one of the very ones that you listed that had, as part of it, a condition that referenced this restriction.
It does not expressly reference the condition, and what their Supreme Court case that I just referenced is
Right.
that it does not have to be both
Right,
either
agreed,
applicable or
but
enforceable.
it has to, but I think it said when you read the record as a whole, it is inferred. So explain to me what you would read if you were looking at the record of those public approval processes that would have led you to infer that this line was a requirement, a restriction
Like-
placed by the government.
Go back and answer that question for you specifically in a moment. In Exhibit D to this, just so you can reference which is one of the original deeds out, and Attorney Gleason also references this. It's on page 2 of my document, I think page 2 or 3 of his as well. It references what the intent of the building line restriction is.
No, I'm not
Okay.
disputing what the intent is. It's clear what the intent is. I'm trying to get at where was a public agency through either directly or by inference saying that was a condition or part of an approval that was given.
The inference is when a subdivision map includes multiple notes and then includes multiple notes that it is part of a subdivision approval that has both been reviewed and has a specific intent. That specific intent is also further included and enumerated in the deed in the restrictive covenant. Those restrictive covenants are also captured in the notes, the
Right.
reference thereto.
But so was this subdivision map attached to part of some government agency saying, we are approving this subdivision pursuant to this map, or
Yes,
something like
the
that.
the subdivision approval references this subdivision map. And the subdivision map itself references back to the prior approvals by both P&Z and ZBA that also contain this particular notation.
The map or a specific notation?
The map and the notation specifically. So if you were to look at, give me a moment, the variance, we look back to the calendar, 41/1982. Public hearing was held. Applicant seeks variances of the sections. Evidence was presented that the neighboring properties, the opposition. I'm sorry that I have to do this with you, but to answer, I just need to reread through that. So the subject premise affected, they referenced that there in the original, and then we go to, I'm looking at the variance application from 1982. Now I'm looking at the calendar. Is that an issue? Referencing which variances were approved. There was a map that was attached when we look at the item K.
So to the variance application, this map was attached?
Well, a previous draft of this, because the procedure was that the variance needed to be approved to demonstrate that there was underlying zoning compliance to allow the subdivision to be approved. So this was, if we look at the documents I gave to you, the full application, you can see the map. If I
Okay, so-
can
so-
approach you,
yeah,
you know,
please.
there's a map.
Sorry.
That's okay.
Or you can tell me what exhibit.
No problem, it is here, I'm just gonna, I can pass it to you,
Okay.
put it in if you'd like.
But this is a map that was
It's
part
very-
of the variance
This is part of the
application?
variance application, this is in your record, the full record that you
Right.
have.
And
If
it
you'd like to
shows,
see
it shows that line
This
there?
building, yes, the building restriction line is very faint, because this is very small. It's right here,
Right. And I presume one of these notes references it?
one of the notes
Okay,
references it
okay.
there.
I got it.
So you see it right
Okay.
here. And then it's carried on as it goes through each of the subsequent approval process with P&Z, CAM, flood, the others that I mentioned, and then the actual subdivision application itself.
So your argument is not, we or a board laid that down as a formal condition, but in all our approvals of this subdivision, that map was included that had that restrictive area. Therefore, if you read it as a whole, then it was something that we approved and was a condition to our approval.
Yes.
And is enforceable, and not that we can enforce restrictions between two private parties, but that by going through this public approval process, it's basically, we're regulating our own restrictions, not.
Yes, and that there was evidence on the record dating back to the earliest approval associated with this subdivision of disclosure of some limitation on building. I do think that it's specifically relevant to a variance application where you are varying, and sometimes you often see those gifts. I understand it may be speculative, but I think that it was critical to me to be able to locate that line in the variance file.
Okay, so just one last question for you?
Yes.
Just to cut to the chase. State law requires an appeal to be filed within 30 days of constructive or actual notice of the approval that was granted. Did you comply with that?
Yes, we did comply with that. And I know there is some information to the contrary to that point right now. But Dr. Gold received constructive notice of this, and we've always been operating that. It had been happening the week of February 13th. And the facts are critical and easy to review with you. December 6, 2022, we received, the Seulers received their building permit modification. This was a modification to a prior application. It was a CAM application, which means it's usually on a public hearing. agenda, but it's not a publicly noticed meeting, meaning that you do not need to tell each of your neighbors that you are going to have this meeting. Therefore, here's the one. This is a pedestrian easement, which will be critical to my next point. So Dr. Gold had no notice of the December meeting, had not had any conversations personally with her neighbors about that modification and that it would be located over the building line. And then December 16th was the date that the building permit was filed, and then January 10th was the date that the building permit and decision of the CEO was subsequently issued. Again, neither one of those things, of those actions, require notice to a neighbor. And if you're not worried that your original pool was not located in an area that was not within a sensitive building, a restricted area, you have no reason to keep your antenna up, to constantly be looking for modifications. And if your neighbor's not going to tell you about it, how would you know?
How did she receive notice, constructive notice?
Coming to that right now. February 2nd, Dr. Gold listed her property for sale, and it went up on the MLS listing. She subsequently had a broker's open house scheduled for February 7th. On February 6th, she observed these large, mature trees going into this public access easement area. Now, we don't have to talk about that specifically because that's not your jurisdiction, but it's relevant to this because that's an open area, and that's what started this whole discussion, and we found out about it. So the trees go up, blocking the view. Dr. Gold has to cancel the broker open house because now the view that was once enjoyed and desirable by prospective purchasers was completely blocked, and this was burned. These trees were bermed up, and they're quite large. This is where they are now, but they were bermed up and blocking that view. We did contact Attorney Gleason. We contacted the office. They were moved. They're still moved in a location that is objectionable between the two parties, but they are no longer in the pedestrian easement access area. But it has complicated the sale, the sale of this property. So as soon as that happens, now her antenna's up, canceled the open house, and obviously this becomes an issue between the two neighbors. And Mrs. Suler contacts her attorney, and then for an opinion about what's relevant and what the scope of the easement is, and sends a copy of that to Dr. Gold on February 16th. And at that point, she subsequently sends it to her attorney, her real estate attorney, Attorney O'Neill, who's also here tonight, to review the letter, advise her what to do, and she gets involved. She runs down to town hall, thereafter has subsequent conversations with Mr. Woodside, and starts going through the files to understand what happened, and she finds that. And that becomes part of the discussion. 2 weeks later, they engaged me on some of the land use disputes. So the earliest she learned of it was after her engagement with Attorney O'Neill, which we believe is after the 16th. We were just targeting the week of the 13th. And the discussions that were referenced in the affidavit of Mrs. Suler, my client can't confirm or deny. We tried to get her cell phone records to corroborate those dates. But even so, even if they did speak on those on the dates that are alleged, there was no level of constructive notice that was given about a permit. Dr. Gold doesn't remember a conversation about that. She said there was conversations about other personal things. If there was any reference to the pool at all, it was in a much broader and vaguer sense. And when we look at the law on constructive notice, and I do have, this is a letter for your record, which includes my, just the references to the case law that I mentioned earlier. And I also sent to Mr. Woodside the links to the cases themselves.
Jackie, do you have a copy?
Oh, I sure do, yes, of course. And your copy of
The trees and the pool, they want it gone.
constructive notice is facts. It's fact specific. It seeing, for instance, seeing construction activity happening doesn't mean you have constructive notice that a permit's been issued. Or just calling to a zoning enforcement officer doesn't in finding out if there's activity on the site and generally inquiring and not having firm knowledge of what the permit is, the permit itself and what it issued, doesn't trigger that 30-day appeal. An appeal is timely when it's brought within 30 days of your actual notice of the existence of a permit. And it has to rise to the knowledge of understanding what that permit was about, so you know whether or not you need to take action against it. So if there was reference to a pool, there's no problem to have a pool. Everyone has a pool, or has a right to a pool. But is there a right to a pool in that location? And it was really just because of the trees going up in the wrong place that forced, forced Dr. Gold's agents to go through the file and to then find that. So it was raised to them that we saw that this was there. Was there a way to resolve it? It took a while to get the trees down. There wasn't a resolution, and so our only action to ensure that it was put in the right location was to appeal that decision. And that's what brings us to today.
So in the affidavit of the other owner, she explicitly says that she left a voicemail on February 4th, that they had gotten the approvals to install the pool, and that they had a conversation 2.5 hours later in which she explicitly told her that they had received the approvals required to move forward with the pool. So just to be clear, you were denying that the substance of their conversation included communication that approvals had been granted to install the pool.
My client is here tonight, Dr. Gold, if you can nod, is that accurate? That any conversation that may or may have not existed did not include reference to
I think it's
actual
important maybe
permits?
to have, if it's okay.
Yeah.
Because that's like obviously a critical issue.
Mhm.
You need to
Please
come up
come
here.
to the podium.
Up to the podium, please, and give us your name, please.
My name is Leslie Gold. I live at 194 Long Neck Point Road. The reason it can't be true is because that's when I first saw the trees go up that blocked the view that I had, and I had to take the house off the market. There's no way I talked to the Seulers at that time. After that, maybe in April or May, I spoke with them, but that was it.
So are you disputing the call happened at all, or that during the call it was communicated that the pool?
I don't believe that the call happened at all, because I was more concerned about the view being blocked. So I don't know why, I didn't speak to them about it at all, no.
And if I may ask, that your first communication with Mrs. Suler was when you received the letter she forwarded to you about the trees from Attorney Gleason?
Right.
Do I understand, Dr. Gold, that you, when you saw these trees installed, your first action was to call your real estate attorney and not to call the Schulers themselves?
Actually, what happened is my real estate agent was there when it was happening, and she called me. I was in New York, and told me what was going on.
I also can clarify that question. No, the reason why she first called her real estate attorney was because Mrs. Suler sent her a letter. There was no communication. She didn't communicate with anyone. So on the 7th, broker open house, working with the broker, very upset about the trees being installed in this is where it is today. This is not where it was before.
It was
The
blocked.
pedestrian access easement. About a week later, you receive an email from Mrs. Suler forwarded to you with an attachment, and in that attachment is a letter that Mr. Gleason had written to Mrs. Suler discussing the scope of the easement.
Right.
And so that is what started, and so she sent it to her attorney and said,
Yeah,
please. Yeah.
I'm not sure, frankly, I'm not sure that you've answered my last two questions, okay?
Okay.
So let me ask this one again. When you discovered and learned, okay, I guess from your real estate agent, because you were in New York,
Right.
your first course of action was to contact your attorney.
Well, I don't think that that's how it
No,
works.
that's not the timeline.
Well, I just got to tell you that if somebody put up a tree that blocked my view of a beautiful body of water, my first phone call would be to the homeowner. I'm not understanding that, but maybe
Well-
it'd clear up as we go along. Okay, thank
Well,
you.
It's, depends on the person. The way I acted was, oh my God, I'm not gonna, it seemed so out of this world that I didn't think to even call them about it until later.
They also were not living there at the time, they were living in Florida, so.
That's true, too. They were-
I don't know, but I wasn't with you then, but at the time, the timeline was trees, MLS listing, trees, broker open house canceled. The next communication that occurred was from Mrs. Suler by email to Dr. Gold with a letter from her attorney describing the scope of the easement, saying that it was.
So, because I don't believe I ever heard the answer to when did she actually receive constructive criticism? I heard a lot of verbiage, but I didn't really get the answer. So is that how she received constructive notice? Is from the email from Mrs. Seward?
No, and I know this is what, because in that email, which referenced the easement where the trees were previously standing, that is what prompted the call to Attorney O'Neill. Attorney O'Neill came down to go through the files to understand had these been properly permitted. When she opened the zoning file, she saw that there were previous approvals from December and then a building permit subsequently issued for a pool that crossed the building line. It was a happy accident, so to speak. The reason, so as of the date that Attorney O'Neill, we say that's the week of February 13th. It may be as early as the 16th.
So you don't have a specific date
I would say that
of
it's.
notice? You're just the week of the 13th?
Well, if it was the date that Attorney O'Neill came down to the office, we can call it the 16th, even though the letter and the communication included no reference to the pool. And the day that she came down, 16th, 17th, there's correspondence between she and Woody as of the 22nd. So we were saying conservatively, I took that week. And I like to be conservative whenever I take appeals and not be up until the last day. So it was that was our estimation. The first communication that prompted any research into the files to learn about it was the 16th
Because
of
your
February,
appeal was filed on what date?
March 10th.
So even
if I
if
used
it
that
was the
Monday-
13th, right, I get it.
If I was using Monday the 13th to be conservative, that brought me out
Okay.
to March 13th. And we filed it on Friday, March 10th.
Okay.
I have one question, just to orient myself a bit. In this picture here of the trees line, where's the proposed pool? Is it off view, off to the far left, basically?
It's on this side.
It's on this side.
It's off screen. Off screen.
Okay. Does any board member have any questions relative to what Attorney Kaufman has presented so far? Because I want to address another matter relative to exactly whose parcel, and we can go by numbers as opposed to names, that this restrictive deed line benefit, specifically what parcel?
It benefits your clients. I mean, it's.
He's asking you.
I know.
What's your
Just
opinion?
hold on one moment. Let me tell you.
This
It's-
would seem to be of extreme
course.
importance, Attorney
course.
Kaufman. I'm surprised that you're
Oh,
not
no,
aware
I mean,
of-
my head is just in the southern map right now. So the deed restriction, hold on, where's my exhibit D? Is included, hold on, exhibit D. Parcel 3.
And, okay, so the answer to my question is parcel 3.
Mm-hmm.
Okay. Can you tell me what parcel Dr. Gold lives in?
Yes. Parcel 2, which is this parcel here.
Okay, then I'm confused as to why parcel 2 is trying to enforce a restrictive deed line that inures to the benefit of a different parcel.
Because we don't look at this as solely a private deed restriction. That this is also included in public record that is inclusive of the ZBA and the subdivision application that is a public document and thereby enforceable by any property owner.
So you're
subject to-
using that same argument as the one as why the ZEO has authority to enforce it, correct? It's the same argument, am I understanding this correctly?
They're parallel arguments, absolutely.
Okay. Does the board have anything further? Any other questions? Attorney Kaufman, do you have anything to add at this time?
I do not, but I would ask if I had reserved the right to respond to any
You-
comments. that are
you may.
specific.
You
Thank
may.
you very much.
Attorney Gleason, I'm going to ask the zoning enforcement officer up first because I'd like to get his take on what his position is, and then I'd like to allow, or afford really, Attorney Gleason the opportunity to respond to Attorney Kaufman and to your comments as well. Is that okay? Thank you.
Good evening again. I don't have a PowerPoint, but I gave you a little package before. Actually, it wasn't a PowerPoint, but it's not here. I think it's important to understand the progression of these approvals for me. The first one being in February 2021 for the main house, which you have the site plan that doesn't show a pool, already shows the building restriction line on it, so it's already known. In June 22nd, 2021, there's a site development plan approved by the Planning and Zoning Commission that also now has the pool on it, but the pool does not bite across the building restriction line. And the modified pool location, which happens in December 2022, has been looked at by the Planning and Zoning Commission, has been presented in a blow-up version by the engineer that designed the whole pool, and is clearly marked building restriction line. Now, on the site, on the subdivision map, my opinion is, as a planner, is that that line was created to provide continuity, visual continuity from parcels 1, 2, and 3, even though parcel 3 doesn't have a lot line at the end of this, because it keeps having an access. It does have a geometric, it's not shown on this. Yeah, if you want to put that subdivision, that would be great, because I think it's the most important document. Yes, very good, thank you. And that's exactly the way I highlighted the line on my documents, so thank you. So this line, which had been looked at by the Planning Zoning Commission, by everybody who is signed off by the Planning and Zoning Chairman, has not been taken into account ever in this pool installation in the modified plan. There's also no indication on any document that the planning department shall enforce this building restriction line. It doesn't say that in the deed. And all the deed says is, as you brought up the point, is that this covenant is the aforesaid parcel 3 is subject to the following restrictive covenant, which shall run with the land and be binding of the releasees herein, their heirs and assigning, and shall ensure the benefit of the releasers as owner of parcel number 4. Parcel number 4 is the big one, and parcel number 3 is, is told don't build across it. But as we've heard tonight, this is a private agreement between two parcels, one making sure that so that the line of sight is never impacted by anything. They're creating this covenant. There hasn't been any complaint so far from the owner of parcel number 4. We were very surprised to hear the filing of this appeal from parcel number 2, which is not impacted by this building restriction line, nor is it in their deed anywhere.
So your office considered it then a civil matter?
Correct. Purely between two parties. And in my package, I provided the McCord Engineering and the Planning and Zoning resolution that did not involve any of this restriction. So it was on the drawing, but it was not considered something that was enforceable by our department.
So can I ask, I agree with the concept that a restrictive declaration between two private parties should not be affected by or affect the action of the zoning board of appeals. It's irrelevant to us. It doesn't impact us and we don't impact it. But I think there are arguments a little more nuanced than that. Their argument is that when this subdivision was originally approved, this map was a part of all those approval documents. Therefore, it took what was a private agreement and basically made it public by having it be basically, for lack of a better word, a condition to us granting that approval that this building restriction would remain in place. So what is your view as to whether, as part of any public approval process, this line was a condition of the approval of that public agency?
So my personal view, and as the previous director of planning in a different state in Maryland, was that covenants on subdivision superseded zoning regulations systematically. So if we had a front yard setback that was bigger in the subdivision agreement, it had to be looked at. In this case, I have confirmed with my director, and I brought it up with him, that Darien does not do this. We do not have a systematic subdivision. If it's a line that doesn't say enforceable by zoning, then we don't enforce it. So there are difference between different states, different legislation. I haven't seen that in the state legislation.
That was not a condition then to any approval that
Correct.
That line be legally enforceable.
Correct.
Okay.
Did that answer all your questions?
It did, sir.
Thank you.
Any other questions on the board for Harvey? No, we're good. Okay, Attorney Gleason, you're up. Yep.
Yeah, if we could just. Okay. Naturally, we disagree. That's why we're here. So, in my motion to dismiss, I raised two grounds for you to dismiss this appeal. The first is that it's been filed more than 30 days after Ms. Gold, or Dr. Gold, I'm sorry, it's Dr. Gold, was advised by Mrs. Suler on February 4, 2023, that the pool construction was starting. So I have an affidavit from Mrs. Suler that states that she had that discussion on February 4th. It's very specific. She recalls that discussion because, and that was preceded the listing of the property, the installation of trees, and everything else. And she checked, anyway, I'll go into that. The second ground is the heart of this matter. That's a procedural thing, but the real thing is, are you going to impose upon the zoning enforcement official the requirement that because a 1983 subdivision map has a building restriction line, he has to then go, as the case law that Jackie cites, check all the documents in connection with that. the ZBA appeals, the P&Z approvals, and everything else to see whether or not that private restriction line is something that he, as the CEO, is obliged to enforce. And then, let's find out that he says, oh, the pool's going over this restrictive line. Well, then he has to go to the document that created it, the instrument that created it, and determine who is benefited by that. That's a legal conclusion based upon a careful reading of a legal document. And then, in order to go further, he has to go to the benefited party and decide whether or not that's been waived. And in this case, Tom Campbell, the owner of 188 Long Neck Point Road, gave his approval to the Sewers before they started their application process to violate the restriction line. And this is a tempest in a teapot because the benefited party has already said it's okay. And he fully supports them in their defending this appeal. I mean, he's offered to help and other things like that. So I think, as Hervé said, there's practical difficulties in adopting the suggestion that Jackie has here. And the reality is, the approval's already been given by the benefited party, so why are we here? And that's what Charlotte's affidavit says. So,
But, I mean, in all due respect, it's not rocket science to follow this trail and read in clear language who is the benefited party and to talk to the neighbor. And the reason we're here is a little more nuanced than you want to make it seem, which is that the approvals that were granted for this subdivision did include this map, and the implication being, if not, that if it doesn't say it specifically and directly, that that map was meant to be a condition of the approval, and that it was clearly drawn on the maps that were part of the approvals that were given. So why shouldn't one, by inference, read that to be an ongoing restriction that was put on this whole subdivision and not just a private agreement between two parties?
because there's no instrument that says the CEO or the town should be enforcing this. There's nothing in Jackie's had months to find something more than the fact that this map was attached to a ZBA approval and everything else to say, okay, this really is more than a private restriction. It's something that the town should be enforcing. And there's nothing before you today other than the fact that the map was part of multiple applications before P&Z to say this must be enforced by the town, which is a burden the town, it's outside of the authority of the CEO.
Yeah, but with
For
all due
one, no,
respect-
let me just go, Kevin, because it's not part of his authority, for one.
Right, but we regularly put conditions on approvals that we give, and we don't say in those conditions, those approvals, this hereforth condition shall be enforceable by the zoning enforcement officer, but just by the mere fact that it was a condition to our approval would give us the authority at some future date to ensure compliance with it. So similarly here, just the fact that it didn't say this shall be enforceable by the town, I don't think is compelling. The real question is, was it a condition that was part of the approval, absent any specific language saying that it shall be enforced by the town?
There is nothing before you at this point, other than the fact that this map with a building restriction line on it was submitted to the town and part of the approval process. That doesn't impose upon the town a duty to make that, to enforce that, absent something more, which I think the record is devoid of. There's nothing more than that. So let's just go through it, because as has been stated, this is the Sewler property, and they needed variances because the houses didn't comply with zoning setbacks. Dr. Gold's house is way too close to the lot line here. That needed a variance. The Sewler residence isn't wide enough. That needed a variance. What is now the Craig Henrich property, parcel number 1, had adequate space, et cetera, didn't need variances. The house that's shown here has been torn down, the shed's been removed. This house was torn down and completely removed. So, this is Sewler, this is Dr. Gold, this is Tom Campbell, 188 Long Neck Point LLC, the current owner. He has already approved construction that extends beyond the building line, and Charlotte and John got that before they sought P&Z approval. Now, that is part of Charlotte's affidavit, and if you look at page 1 of her affidavit, I'm going to review it very quickly, but it says that the deed which created this states that it's for the benefit of the owner of parcel 4 on the map, so that's Tom Campbell's property. It also says that the Seulers and Dr. Gold have had a very cordial neighborly relationship, and they still feel that way about her, but this is a trying situation for everybody. And, but under Charlotte's affidavit in paragraph 10, she references that she talked to Verizon and was advised that she received, or she had talked 4 times between January and February 13th to Leslie Gold's cell phone. And she got that direct from the Verizon representative.
So how does that work? You call Verizon and say...
She can call Verizon
and say, who did I speak to? And
give me the phone numbers.
But they can't give you the records? They can... How come we don't have the
We
records
haven't
of
had
calls?
time at this point to get, if you want, we could probably get the records from Verizon of it. But I didn't put...
I don't think that's necessary,
But
Wilder, because...
based on that conversation with Verizon, she was advised specifically, and the records will reflect, and anyone can do this if you have Verizon, I guess. You say, you know, this is the phone number, how many times in the last 4 months have I called that number, and what's the length of the calls? And they also give you the time of the call. So in this affidavit, we listed the information provided by Verizon to Charlotte Seuler. And she had a 20-minute call, a 40-minute call in January, and her recollection is that that was about John's health. And that Dr. Gold has been helpful and solicitous in connection with that. And then there was a 2-minute call starting at 9:22 a.m. on February 4th. And Charlotte's affidavit says, that was me leaving a voicemail on Leslie's cell phone asking her to call me because we got our pool permit and we wanted to tell her about it and the plans, et cetera. And so then there's an 11-minute phone call 2.5 hours later at exactly 11:52 a.m. on February 4th. That's February 4th. 11-minute phone call, followed by a 2-minute call on February 7th. Okay, those are the only calls that Charlotte has received. She used her cell phone exclusively when she was in Florida for matters pertaining to this, and Dr. Gold had her cell phone number, and she had Dr. Gold's, because they're neighborly. And she then goes through each of the phone calls, and the most important one is that paragraph 13, where approximately 2.5 hours after she left a voicemail on February 4th, just before noon, Leslie called Charlotte back, and according to my phone records, we spoke for 11 minutes. That's what she says. And we discussed the fact that John and I had received the approvals required to move forward with the pool and intended to commence work in the coming months. I recall that I apologized for the fact that our construction of our pool and related improvements would commence during the same time frame that she expected to list her house for sale. The house hadn't been listed yet. This is several days before. I advised that the warmer weather would allow us to start the pool installation so it could be completed for use later this summer, and that John's physicians had said that would be helpful for his health. And it goes on to say, I may also have advised that we intended to install a line of trees along the mutual property line to provide privacy for people using the pool. And
All right.
Charlotte can't recall what the February 7th 2-minute phone call was. These are very specific representations. They're sworn under oath. They're before you. If you accept those as fact, then Dr. Gold knew 34 days before she filed her appeal, that a pool permit had been issued and construction was going to start.
Okay.
Now, that's ground one. That's technical. I understand you guys don't like doing that, so let's go to the merits. Because, the citations here are 8-7. We did this a couple of months ago on the Hardy appeal of Jeffrey Brown's permit, and because I had published notice and I had that firm, it was locked up. That didn't happen here, okay? We didn't publish notice of the sewer appeal. But Charlotte gave actual notice, and 8-7 says you've got 30 days or whatever time period is specified in the local regulations. Your regulations say an appeal must be filed within 30 days of publication of the decision or determination. And so our feel is that this is not timely. And the time expired on March 6th, and the appeal was filed 4 days late. Now, that's technical. You don't like to do that. I understand that. But the second ground is really, in my view, locked up. The Gold appeal should be dismissed because it seeks to have the ZEO enforce a private restriction, not a zoning regulation. So the deed that created it is before you on this page, and it's a deed from the executors of the estate of Louise Eden Guile, and they are giving the property to her widowed husband, her widow, Laurel V. Guile, and Robert Miller, and John McConaughey as trustees of a certain trust. And this is a quitclaim deed, and it conveys 3 parcels. It conveys parcel 1, what is now the Henrich property, parcel 1, which is the Henrich property on the map, parcel 2, which is Dr. Gold's property, and parcel 3, which is the sewer property. And only the sewer property was subject to any restriction pertaining to that building restriction line on the sewer lot. And it says, the conveyance of the aforesaid parcel 3 is subject to the following restrictive covenant, which shall run with the land and be binding on the people who acquired it, meaning the releasees, the buyers of this, their successors and assigns, and shall inure to the benefit of the releasors, the sellers, their heirs and assigns as owners of parcel number 4. So it's solely for the benefit of the owners of parcel 4, Tom Campbell. If they wanted to give this right to Dr. Gold or her predecessors, they could have, this same deed could have said parcel 2 or parcel 1. The person who created this did not intend to give rights to parcel 2 or parcel 3, irrespective of what happened before the Planning and Zoning Commission.
So Wilder, so it sounds like obviously you think the Sewellers were well within their rights to put up this tree line, to do the pool, all that being said. But did they, when they found out that Dr. Gold was unhappy, did they make accommodations? Was anything done?
They have removed the berm, which should not have been installed. They have relocated the trees, and they are frankly going to move those trees elsewhere and reinstall the line of trees. That's their intent at this point. They are fully within their rights. I've had that discussion with Jeremy and Hervé. There's nothing to prevent them from doing that.
Okay. They gave the consideration, and now they're going back to what their rights allowed them to do.
Yeah. And there was an error in the communication. The sewers were in Florida. The contractor was up here being supervised by their daughter. The trees went in. It was not a good thing. I went out there, and I'm really glad that we've moved them, okay? Because it was not the right thing to do. So, this restriction is solely for the benefit of parcel 4. And as Charlotte's affidavit says, we got the approval before we started seeking zoning approvals. What else do you want us to do? If the intender here had wanted to give Dr. Gold the right to object, It should have been in this deed. And this deed, by the way, is recorded in November 1983, and the subdivision map was recorded in February of 1983. So the subdivision map existed for 9 months, and the approvals existed for 9 months before any document clarifying what the developer's intent of the building restriction line was filed. It occurred 9 months after the whole thing was subdivided. And that, you know, if it was something that should have been part of the P&Z approval, you'd think it would have been part of the documents that the P&Z would have required. If P&Z thinks it's going to enforce something, they want those documents now. They look at them and they want them to review them to make sure they're going to work. Restrictive conservation easements, open space declarations, those all get approved before you get filed. This was filed 9 months later. Huh? Who's benefit for it? Only Tom Campbell, not mentioning Dr. Gold or Craig Henrich's property. This is the only document that uses the intent of the developer when he put the building restriction line on the map.
May I ask a question, because I heard you reference that Mr. Campbell was willing to help or is helping in some way or any way
It's an
he can.
expression of sympathy.
Understood. Is he in attendance this evening?
No.
Okay. The reason I ask, and if you know the answer, great. If you don't know the answer, it's perfectly fine. I'm just curious. When did he buy this house, parcel 4?
I think in 2000,
6 or 7 years ago.
yeah.
Okay. I mean, I know this is not being, it's not, you're not going to be able to answer this question. I'm going to ask it anyhow. Did Mr. Campbell know of this restrictive deed line when he purchased the house? I'm curious to know that. And did he understand that it was inuring to his benefit only?
I represented the Sewers when we sold to Mr. Campbell. You would
Then
have to
maybe you
speak
do know
his
the answer.
attorney, because his attorney would be explaining that to him. But knowing that he had the right to enforce it, when Charlotte and John discussed their plans to create a different pool that extended beyond the building restriction line, I advised them that we had to get Tom Campbell's approval, and it took a while, but we got it.
Okay, thank you.
Wilder, you just said something about 9 months. This was 9 months after what?
After the map 4168 was recorded. So if this was supposedly going to be enforced as part of the Planning and Zoning Commission, you'd think P&Z or ZBA would have required this to be filed in February when the subdivision map was filed in the land records. That created the 4 lots. It was only after, because I don't think, who knows? What happened is the developers then quit-claimed it to these trustees, and they quit-claimed 3 lots. All of the other 3 lots, not the great big one. And they protected the great big one that the owners wanted to keep. And what were they doing? I think everybody's absolutely right. They were protecting the water views of the big house. And I can tell you, having had the privilege of walking on that property when the Sewers owned it, they were magnificent. And they were compromised when the Studi house went in next door to the Sewers, down right by the water. And anyway, that's...
So I guess so I thought we heard earlier was that portion, that language, which is pretty critical about, who it's for the benefit of, was part of the subdivision decision in, what was it, 82 or something like that?
Absolutely not.
It
It wasn't
not.
even created until
5, 6 years ago.
this deed. This is the first evidence
So
you have
where
of
did
what
the- where
needs
did
to
the-
And this deed is 9 months after that decision to subdivide.
9 months.
In 1980, whatever.
1983,
1983.
subdivision map, when you look at it, it's recorded February 1983. This is recorded, and the receipt, the recording and receipt is at the bottom of the
But didn't that
last page.
subdivision map include this restrictive line on it? Where did
Yeah.
that come from? So who invented that?
I assume what happened is that may have been the developer's intent that ultimately he was going to put it on.
memorialized here, right?
Yeah,
So
and
then-
it's realized here, but
But doesn't this hurt your argument then? Then can't you take the position that the town approved of a subdivision that included a line that wasn't even a legally required restrictive declaration at the time, that came later. So doesn't that stand for the proposition that the town approved of a subdivision that had a line on it that didn't inure to any specific person's benefit because this came after?
But if the town is going to enforce it, they ought to know at the time they approve it who's benefited, what the building restriction line is supposed to do.
But don't the notes say what it's supposed to do?
No, the notes say nothing about that. The notes reference ZBA approval number, calendar number, and this, and special permit approval given by P and Z.
Listen, no one's disputing what you're saying here about who it's for the benefit of. The question is, to say it in a very simple way, did the town see the restrictive declaration agreement between the two parties like, oh, that's a good idea, let's make that part of our approval?
This is not part of
I
any
know it's
record in
not, but
town.
the concept clearly was at the time because they're.
But no, the concept, you know what happens, P&Z doesn't look at everything, they're looking at it for zoning compliance. They don't look and see, oh, here's a building restriction. What do you mean by that? They don't go into that. They've got enough on their platter. They're looking for compliance with zoning. And that's a private line that will be defined by an agreement later. And they just don't enter into that. That's unrealistic to expect that. And the burden that you put in doing this on a CEO, if you adopt her interpretation, airbase, we're gonna need 5 of them.
No one is saying that the CEO should be charged with enforcing or caring about private agreements between parties in relation to restrictive covenants, whatever, or easements. The question though is, was that what this is, or was the town itself adopting this as a restriction on those properties?
How could they adopt something that they didn't even have when they approved it? They didn't have the language of what the building restriction line meant, and it wasn't available until 9 months after the map was filed, and that was probably, a year plus after the P&Z approval.
Well, I mean, I guess that will be a follow-up question about whether
Yeah,
whether the notes include.
And that's one of the
detail.
practical reasons why. So let's just go to the town ordinances. Oh, sorry, gotta get that out of here, sorry. The zoning official shall be referred to as the zoning enforcement officers. This is your town code of ordinances, that what his authority is, okay? And the zoning official shall be responsible for the enforcement of the zoning regulations of the town of Darien, and shall have such other duties and powers to effect enforcement of those regulations as are or may be vested in such officers by towns pursuant to the general law. There's nothing about enforcing private restrictions. Now, Jackie's point is this private restriction was incorporated and it should have been enforced by the ZEO. I just think that's far-fetched given the facts. It just doesn't make a lot of sense. So zoning regulation, you've got this is my, primer for those who don't understand the difference. Zoning regulations control the use of land just as a restrictive covenant does. The zoning regulations adopted by the town pursuant to a comprehensive plan of development for the entire town. The private restrictive covenant is created by private agreement. That's what happened in this case, private agreement. The zoning regulation affects the whole town, it's town-wide. And you guys are the arbiters of justice to relieve the pressure when the regulations don't work as applied to a particular piece of property. That's your job. That's part of the whole scheme of zoning and regulation of land use in towns. In a restrictive covenant, it only affects the covenant only affects the land identified in the agreement. It's not town-wide. The regulations are enforceable by the town ZEO, and the restrictive covenants are enforceable by the benefited parties, not the ZEO.
But you're missing a third category, which is conditions put on a discretionary approval given by a town board.
So she hasn't pointed to any, I'm sorry.
I know, I'm just saying,
I
yes.
apologize.
That's your argument, I hear that, but I'm just saying there is a third category that would be enforceable by a town ZEO that doesn't meet those criteria, which are conditions put on by, say, this board, for example.
Right, your conditions like, you can't come back, well, you can't come back for another variance, but you can't enclose this porch if we give it to you. Those sorts of things you do. Yeah, those are, but that's a condition specific. It's written, it's clear. You don't have that here. What you've got is a line on a map that was part of a bunch of approvals and nothing else.
That's the argument. Okay.
So, in our view, you should dismiss the appeal because it's not timely. And secondly, the CEO has no job, no right to enforce this private restriction. And in this particular case, think of it. He failed to issue a permit because there's a private restriction. And then it turns out the private restriction benefits parcel 4, and we've got the approval. How do you think the town looks like if that's what goes on? And he's then trying to defend, he says, well, the town has a job to enforce this restriction, even though the benefited party has waived it. That's what would be the effect of what she's asking you to do. Despite the fact that Tom Campbell signed off, she wants him to say no. That's a stretch.
Okay, thank you.
A quick question for you. There's a pretty steep incline of where the pool is going to be going. Do you happen to know what the grade is of the pool? Like, where on that grade does it sit? Is it being built up to, or?
No, it's down from the house. It extends, it has the end of the pool. Parts of it will be exposed, okay? But I doubt that the pool is visible at all from the Gold House. But it would be visible if the Gold House were removed and a new house were built in the rear of this property. And then they would be looking at people in the pool, which is a privacy concern, why the Sewellers decided to put the trees in. Perfectly legit.
Okay. Thank you very much. Anybody else have anything for Wilder? Everybody okay with him? Okay. Attorney Kaufman, would you like to
Yes, please, thank you.
rebut?
I think we've already made our statements clear about the record and the timeline. Realize there's differing information there, but both of those opinions are both valid. Stated in the record, stated in affidavit. If there's anything else that you would like from my client, she also tried to pull cell records today in preparation for this meeting and spent almost 2 hours trying to do so with Verizon, and it was not easy to do. So that's accurate. Certainly can follow up with any other information that you want for the purposes of your decision on that, but I think you have all the information that you need from us. Constructive notice as early as the 16th because of inquiry, personal inquiry that had to be done. You asked the question about forcibility. Where was that map? So while Attorney Gleason was speaking, he was talking about it not being recorded until far after the approval. And that's somewhat disingenuous. As a land use professional, you are required to put all of your documents in as draft documents for review by the reviewing board, in this case, the Planning and Zoning Commission. And we saw that this document first appeared before the ZBA. That same document proceeded through the record. There is not an extensive file on this because it doesn't include every single draft, but there are several pages. This is a copy of that map, again, I have here out of the record, and which I think is included. I've included everything in your file as well. And it is dated May 19th, 1982. And in the approval document itself, it says, whereas the application has been made on July 20th, 1982 for approval of a subdivision map entitled, and it's this document that we've all been looking at, subdivision map prepared for the estate of Louise Eden Guild, Darien, Connecticut, dated May 19th, 1982. And then there it goes by, talks about the coastal site plan approval, the flood prevention, damage prevention approval, and also the subsequent subdivision approval, and all of the requisite documents that were reviewed in association. Most of that have to do with engineering and infrastructure. The whereas clauses speak generally to the information on this map. where the public hearing was held in July. The details were set forth in the materials located in the permanent file of this application and by the statements of the applicant and others whose testimony is contained in the record of the public hearing held thereon, all of which is to be incorporated by reference. I think that would corroborate the finding of our Supreme Court as well, in terms of what it means to search the record and why it's important. It's included here in the whereas clause for this very application. Whereas the variance has been granted by the ZBA, calendar number, to permit the existing parcel to be legally subdivided and therefore is an integral part of this application, consistent with my statement from earlier today. Whereas the Commission finds through their detailed review of the proposal that the applicant has taken care to preserve the natural character and natural features of the site by proper design of the subdivision in due recognition of its amenities. And as part of its deliberations, as authorized by the zoning regulations, subdivision regulations, and Public Act 79535, I don't know what that is, the proposed subdivision generally complies with town regs. Considerable care has been taken to permanently protect and preserve valuable coastal resources located immediately adjacent to the westerly side of the property. And that certain hazardous flood zones exist on the westerly side, and such zones have been permanently protected and preserved in their natural state in the subdivision and restricted from use for development purposes. That's not a direct reference to the building restriction line, but may be interpreted to encompass that, because we have no building restriction line, which prevents where you can build. And we have open space, we have flood damage, we have setbacks, I mean, all everything that I just referenced here. And it references back to the map, and it references back to the ZBA approval, which also includes that same map, which also includes that same building line restriction. So you have this, but if you'd like
But
this, happy to.
that's important and helpful, and that certainly helps your argument, but does the map that was approved, the map that was attached to the ZBA and other approvals back then, does it have a note that calls out what those restrictions are in terms of what can be built within that, cannot be built within that restriction
It does
line?
not expressly say that, no. It just, it includes that same note. And what's important is the continuity of the disclosure. If it was not on the ZBA map, I think that it would be more, that might be a more challenging position right now. But the fact that it was on that map and that we see consistency over the course of the year and a half, from the time that the ZBA application was filed and approved through the subdivision and the subsequent filing of the subdivision map after the approval.
What would have happened if the deed restriction was never filed for whatever reason between the parties?
I don't think that's relevant.
Yeah, how would the town know what that general language meant about protecting the coastline and, you know, permanently restricting development? How would they know what that would mean?
I think one thing that all commissions learn over time is that the more detail that they give, it becomes more efficient for later parties, so they understand that. We make a joke often when we're all, after we win the lottery and we're on a boat to Bermuda, let's make sure that this is papered correctly. And I say, I look back this way, just put my colleagues into staff. We make jokes like that so that we can keep a very, very accurate record, and that's part of this process. But also in the final comment of this approval, it says, all provisions and details of the plan, capitalized, meaning this plan, the subdivision plan, as set forth or requested herein to be amended, shall be binding conditions, and this approval shall become final upon compliance with these stipulations and the signing of the final plans by the chairman.
So the plan is a defined term. Where is it defined in the document, and what is it, how does it?
Subdivision map prepared for.
So the plan is defined as the subdivision map?
Plan. I know it's capitalized here. Maybe I'm making an assumption. I don't see it as, this word is plan.
So read that again. It's the plan is a condition. Read that last part again.
I'm looking to see where the word is capitalized, but I don't really see that. But it's capitalized, so I assumed that it meant, I'm presuming that it references back to the map, but that's what we usually do.
Just read that one last time.
All provisions and details of the plan as set forth herein or as requested herein to be amended shall be binding conditions, and this approval shall become final upon compliance with these stipulations and the signing of the final plans by the chairman. Plans, I would assume that meant this is typically the plan. It's the subdivision map of the subdivision plan. I can give you.
Okay, anything further?
No, I have nothing further. Thank you for your time tonight, and if there are additional things that you need, we would like to provide them to you. We think that at this point that the permit should be rescinded, and the applicant should, if they choose to pursue a compliant location, return to planning and zoning for that permit.
Okay, thank you, and I apologize, I just want to make sure the board has no other questions for you. Okay.
Thank you all.
Yeah, oh, Woody, I apologize. Sorry. Woody?
Jackie, I think you cited some cases, like the Supreme Court and other, do you have
Yes,
those?
they are referenced in that document, and they've been emailed to you with a copy to Attorney Gleason. They were emailed to you at the beginning of the meeting, so no time to stop the copies.
Tonight, oh, okay. So we don't have those in the record, actually.
Well, you do have them in the record. If they're, I'd like to incorporate those into the record, which have been sent to you by email, which was prior to the start of this hearing tonight. It was sent by Dan. I mean, otherwise, they're referenced in there, and you can certainly find them. Your town council has access to the Westlaw because the full case citation is included. Or if you'd like me to send them at this moment to someone else.
No, I think we're okay at this point. If we have anything.
I think if they're incorporated by reference into the document that you have before you, that.
Okay.
by
If
law,
we have
they're
anything
part of the
further,
record.
we'll let you know on that note. Yes, please make your point quickly. We're going on 2 hours here, and I need water, so. Well,
Yeah. You know what?
can I ask a question, and I'm probably getting in trouble for asking this? Why can't the Schulers just move the pool back 10 feet that I mean, it's such a small little.
They've spent 2 years on this project. It's
Yeah.
an important, they've invested a lot of time, effort, and energy in getting the approval of the person who should have approved it. And they never anticipated that we'd be in this situation. It just, and I'm not sure why it's such a big deal for Dr. Gold that the pool is 12 feet beyond the building restriction line. But whatever it is, it's there. So,
No, it probably has something to
one
do
thing
with
I
the
want to
view,
point
but
out-
I'll leave that alone. You don't want to
That's
go
a separate-
there right now.
Exactly. So the references in the resolution that Jackie was quoting are reference to the plan, and that's the map. And the map has conservation easements and open space easements all over the waterfront of this property. The Sewlers have a huge easement near the waterfront. It's the conservation easement. And then there's an open space easement, then there's a conservation easement, and then across what is the 188 Long Neck Point Road property, there's a huge conservation easement that protects the lawn. And that's the reference that was being made in that resolution, all this protection, et cetera. That was part of the deal in order to get the variances and to get the other stuff. But nowhere does it specifically say, and she has still not pointed out, where the building restriction line is part of the P&Z approval that must be enforced by somebody. It's a big leap that she's asking you to make there.
Okay. Everybody okay with Wilder? All right, good. Thank you very much.
Thank you.
Is there anybody from the audience who would like to be heard on this matter? Fairly large audience for nobody here to make comment. Okay, then this hearing is closed. Thank you. Okay, well, I expect the room to start to clear out a little bit, but Mark, you're up next. Would you get ready while I get some water, please?
Absolutely.
Thank you, sir.
It's hard sometimes. Whatever's fastest.
I know it's gonna be a tough. I know it's gonna be a tough
I
night,
think
and this
they-
is part of the
You guys had a
package.
basket?
That's
I think
bad
you guys
news.
put it in there and like lost it down.
Didn't notice it tonight.
Shouldn't say bad, shouldn't say long. Better word.
For us.
I feel like Stanford, I expect that. You guys are very. But that's a big city, you know.
Well, it is. Very valuable property.
This is,
That's what I like
in
about
my,
it.
I don't know if these are existing or not.
Okay, we'll try to find those things. Yeah, I know. How are you?
Oh, those are all there already.
Are they deciding this tonight?
Maybe. You might want to hang around. We'll probably at least start with those.
Yeah, maybe that's his. I don't know.
Basically, sliver of a view right here.
Yeah.
And look at two. This is fucking east of it, like an entry. So, it's not. It's like east. Guest house.
I know, sorry. I should have tucked it in.
That's okay. Where'd Mark go?
Mark, he's hiding back there. I see.
Oh.
Okay, good. He's there. Good job, Mark.
Sorry about that. I'm like, I told you to get ready. Okay. All right, I asked you to get ready. All right, we're moving on. Calendar number 8, 2023, the application of Mark LeBeau on behalf of Sarah Whitman and Ryan Baxter for the property known as 11 Raymond Street. Mr. LeBeau, in light of the hour, as quick as you can.
Oh, boy. Well, good
No,
evening,
you,
everybody.
you have time. I'm kind of jesting.
No, I hope so. But in any event, it's good to see everybody, be back here in person for the first time after many, remote meetings since then. I can tell you our application tonight is nowhere near and certainly legally complex as the ones that you heard previously. Again, I'm Mark Lebo with Seymour Surveying. I'm representing the Whitman-Baxley application at 11 Raymond Street. And here with me tonight, as is Ken Epley and his son Brendan from sorry, space it out here. ERI. I'm so exhausted at this point. I was in the office at 6:40 this morning, so it's been a long day. And I'm sure it has been for all, yes.
I knew the answer.
Spacing out a little bit here. So, if you've been through the application materials and through the item K, you know we have a fairly distressed lot here. It's roughly 4,120 square feet, about half of what the minimum lot area required for the R1/5 zone is. The subject property was created effectively by subdivision, but since subdivision regulations didn't exist at that time, we call it a simultaneous conveyance where several lots are laid out on a map at the same time. That was in this map 209 of the land records, and even prior to the adoption of zoning regulations in December 1925. The house, according to the tax records, I'm going to call it a house, but there's a little history here. The house, according to the tax records, was originally built in 1941. It's my understanding through some conversations with Sarah that this building actually served as some sort of an accessory structure for the Rowayton Fuel Company, possibly as a garage or some type of thing like that. This is evidenced by the extremely beefy foundation that this house has, and some other structural elements to it. The lot is an unusual corner lot in that it effectively has 3 street frontages and thereby definition, only one side lot line. And due to this unusual condition, as I've kind of mimicked Woody's sketch that you have in your packages here. So right there in the center, there's approximately, I think it was 32 by 15 or 30 square feet in area as of right building envelope. So obviously, you know, we have some hardships with respect to that.
Excuse me, I'm sorry.
I'll close it.
Close it, tell them to leave, do whatever you have to do.
Yeah, you can just close it. They're settling everything out back.
Yeah. I apologize.
Yeah,
Just-
no worries, certainly understand. I've been
I'm having a hard time
guilty
hearing
of
you.
the same thing at myself.
And it's
so.
unusual that there's a lot that has 30 square feet of building. That's unusual.
Yeah.
We have what's unusual, we have the hardship that you can't build anything legally. So what do you want to build that's the minimum adjustment necessary?
Well, we would like to erect a second story. We're just going up immediately over the existing footprint.
And so what will the total square foot of the new house be? And
As far as the footprint or the
just
living,
total square feet of what's there now and what you're gonna add?
the footprint doesn't change.
But
In fact, we're
volume,
reducing
I'm saying,
building coverage.
volume, like how much additional volume are you putting on? And what is the purpose of it?
Well, we're the living space will be probably about doubled in size, maybe a little bit more.
But what is that number?
Ultimately, it's gonna be roughly 1,950 square feet of living space, so
Okay, so
still,
hang on. So the finished product is going to be 1,950 square feet.
approximately, yeah.
Okay, I'll give you a couple of feet. And before it becomes 1950, what is it today? Half of that?
Roughly 960.
Roughly 960.
Ken Epley.
Kent Epley, ERI Building and Design. So the numbers are actually,
Well, we have, you can flip these over.
it was, I think it was 818 is the first floor of the existing house right now.
Okay. So, we're just curious to see what kind of volume we're talking about.
You're keeping the footprint, you're going up, so you're doubling the size.
Well, is that the basement
Sounds like
number?
more.
We're using?
818
Yeah.
times 2 is
Oh,
1636.
total square footage on the first floor is 818.
Okay.
So we're talking about doubling that, and then there's a little more square footage that we're asking for in the basement.
Okay.
In where the garage is.
Quite a
Okay.
bit. Quite a bit.
300, 400 square feet.
What's that?
How many square feet in the basement?
In the, oh, the
So we're
basement.
asking for 332 in the basement, where we're allowed 409 technically.
Okay.
Where did you get the 409? I'm sorry?
It's half of the
Half,
first floor.
Oh, I understood.
So
Sorry.
302, okay, basement.
yeah, that's all noted on the floor plans in the submittal.
Yeah, I got it. Okay, good.
Okay.
I'm good.
So essentially, there was a side porch we took off, reduced little, but some square footage, and then the hope is to go up and over what's there.
Mm-hmm. Okay, all right.
You're using the existing foundation?
Existing
Yes.
foundation, we've got a letter from the engineer, he's
Oh,
looked at it.
yes.
Everything, it really is a very well-built structure. Whatever they use it for, it was like back in the Roy fuel days, sometimes they would park trucks on that first floor. So it's a very well-built, what is there is well-built, but we will need to take the roof off, the first floor ceiling joist off in order for the new joist to support a livable space above. So we're planning on leaving the foundation, first floor walls, gutted to the studs, modifications for windows, doors, and going up front,
Okay, fine.
up and over what's there.
Understood.
Like to submit
Mark,
for
you
the record,
just-
a letter from the structural engineer, something that Woody had inquired about, so I
Okay.
just have the one
Hey, you can
copy.
give that to Woody. Thank you very much. And have you finished answering Kevin's question about the minimum adjustment necessary? I want to make sure that that's on the,
Well, in so much that we're going up over existing, we're not increasing any of the horizontal nonconformities, and we're within the building height requirements. So ultimately, I would have to say, in effect, there's no increase in the nonconformities. So
Well,
is it
you're-
the
you're-
minimum,
you're-
is it the minimum adjustment in what sense?
So what the statute says is, we can give you a variance if there's something unusual about your property, and that's what we've defined. If that has created a hardship, which I think it has, because you only have 30 square feet, so the hardship is you can't build anything to live in. And then the last test is the thing that you want to build the minimum adjustment necessary to give you substantial justice in the use of your land? In other words, can you do something fairly reasonable with your land based on the adjustment that we're giving you?
Well, I don't think it's to say that if you were building this house, if the lot were vacant, or they could have built a two-story house at the time the house was originally built. So I think we're well within our right to ask for that. I think, what would the alternative be?
No, it's subjective, in my view, which we can talk later, is that 1,950 feet is minimal.
And it's a very modest house,
Yes.
even when it's done, it's a very modest house.
I did answer it sufficiently.
Okay, good.
And the building coverage is 20.5% in the end.
Yes, and so we're ultimately reducing it from what's there. And, as a function of the lot area at 4,100 square feet, that 0.5% is roughly 20 square feet over on coverage.
Okay, I understand. Woody, I just want to make sure that you're okay with this particular issue having to do with coverage, because I seem to recall, there's a lot of paperwork this week, but
Yeah,
I seem to recall a note from you saying that the coverage is going to actually increase from 20 to 20.5. Was that just a typo?
I think it's actually.
He said it
I know, I know.
20.5,
But-
yeah.
would be
Yeah,
reduced
from 21 to 20.
No, it's always been on the survey as from 21 to 20.5.
But I just wanted, listen, as long as Woody's
That's right, there's
okay,
notes somewhere else.
That was-
there is a note
covered,
somewhere else,
yeah.
because we discussed it last.
Well,
Yeah, we did.
try to at least,
No, understood,
Minimal,
not your issue, sir, I just want to make sure that Woody's okay. That the coverage is actually decreasing by 20 square feet. I
Just by
guess.
taking off the portico.
Yeah, understood. Okay, good, as long as he's okay, I'm good too. All right, can you tell me about the fence? Because there's a fence on the property that's not only 6 feet high, but apparently it's created, not apparently, because I've seen it, it creates sightline problems. So what are we going to do about the fence?
Well, I'd like to, so I took some pictures there today. I mean, let's face it, Raymond Heights is nobody's speeding on Raymond Heights.
Well,
So,
you haven't seen me drive.
Well,
Or Barb.
Yeah,
so I took some pictures of the street today. Get to the fence ones. Okay, so. This is the fence you're talking about. And I'm standing on the curve of Raymond Heights. The Baxley house, or the Whitman Baxley house is right here on the very right edge of the photo. This is the fence in question, and you can see several lots up the street from the position I'm standing in. So is it really a sightline distance? And when you sight distance issue, and secondly, when you take into consideration the fact that the road itself is encroaching up to, at its max, 8.5 feet onto the property, you would hope that some relief could be given to provide them with some level of privacy, considering not just the 8.5 feet, but the 270 square feet of road that's on their property.
Okay, well, that's not
So
a bad answer, but.
We just want, I think everybody wants a little private outdoor living space, right?
I don't
So-
disagree with you at all,
And if you go up, and granted, albeit not on, this is standing a little further up Raymond Heights, looking back towards the Whitman Baxley house. You can see there's a rather lengthy 6-foot-high fence, albeit on the straight portion of the road. And that fence line kind of continues even further up Raymond Heights. So it's not out of character. This is not the Baxley Whitman fence. This is 2 properties up Raymond Street. So that 6-foot fence extends for 3 lots up the street.
Yeah, those guys are next. I mean, we don't like that stuff. That's against our rules.
I mean, there's not a
Well-
variance for this fence,
Yeah.
is there?
Mr. Lubo,
Okay.
Please.
What do you
and this upsets me. Look at this damn picture. You try to drive up that road, up Raymond Heights, and go around that curve right in front of this property. This is what it looks like, not that picture. It's a safety hazard. It's clear as can be.
Well, that's, I suppose, one opinion.
That's what you see when you're in your car trying to go around that curve.
Okay, so let me ask a question. Is, Woody?
Pardon me.
And as far as, I think Barbara, you mentioned something about this. We've made some inquiries into this, and I can't, because you're gonna take this as hearsay, but there was a situation on Brookside where somebody replaced a 6-foot-high fence right on the road. There's a driveway that comes out. There's a 6-foot-high fence on either side of the driveway to a 6-foot-high fence. Apparently, the situation was when it was inquired by Fred, to Fred in the planning and zoning office, he basically said, well, it's kind of legally non-conforming and we're just letting people replace them. So there seems to be a difference of what's okay in one place and maybe not so okay someplace else.
Well, I understand the comment, but in this case, what I'm really more concerned about is the sight line. I'm not bubbling over, I don't know why I said that, but I'm not terribly concerned about the 6 feet. That I would leave that to the CEO, quite frankly. And I'm not here to sick the CEO on you. I'm here really more for protecting the public relative to safety.
Sure. Well, let me ask you this. Would it be the type of thing where if the fence were not solid but 6 feet high, would that be, just so that it would afford the homeowner some privacy, yet not totally obstruct the sight line, as Mr. Woodside claims?
Right, I understand his claim. So, I'm asking this question, and maybe it's more to myself, but anybody can feel free to answer. Will a 4-foot fence actually cure this sightline problem? I don't know, and I'm not too sure that it would. So I'm not too sure exactly what to do here with this fence issue.
I mean, there are fences all over town that are not in compliance. What we try and do is when people come in front of us, we ask something back. Take that illegal
Sure.
fence down, take down that treehouse, lower that fence, to try and get things, that's all, that's the nature of it.
Conforming to
Yeah.
our regulations, that's all, but
It's a lovely fence, it looks like it was put in recently.
it's a nice fence. Okay, so look, I'm gonna,
You'd have to come up to make a comment.
yes, you will.
Yeah.
Thank you. Hi, I'm Sarah Whitman. We put that fence up 2 years ago at this point when our neighbors were doing construction, and we actually replaced it. There was a chain link fence that was 6 feet tall there that the neighbors, which I have a neighbor here, no one liked it, so it's really ugly.
So you put up an illegal fence 2 years ago. Thank you, Sarah.
Appreciate your
It's
candor.
a lovely illegal fence.
We replaced it.
Yes, the board appreciates your candor, Sarah.
Okay.
Okay, thank you.
Thanks.
Okay, listen.
Well, I suppose, if we could come to some sort of I don't think anybody has any objection to coming to some sort of a compromise, but as you pointed out, Jeff, is 4 feet gonna make a difference? Because when you're sitting in the car, the fence is still gonna be taller than you.
I know. And the fence is on your, okay, you can come on up and say hello and introduce yourself.
You have to come up.
You have to come up.
14 Raymond Street.
Okay, come on up.
You have to come up to the microphone because it doesn't pick up the
My name is
sound.
Diane Mack. I live at 14 Raymond Street. And I just want to give you a common sense solution.
Mhm.
There are several trees around that bend. I've had this situation in a home that I lived in Ridgefield. I put
A mirror.
A mirror. Simple solution to a problem. Done deal.
Thank you for your idea.
I'm sorry, save,
Insightful.
so that you don't
No pun
spend 2
intended.
hours between trees and pools. Just a
Yes,
mirror.
I understand. Believe me, I understand. Okay, I'm gonna move on from this right now, unless the board has any other questions, comments, or concerns about this
Is
Is
this parking, is this part of the variance request,
Yeah,
any, have to do with this parking situation?
Yeah, there's two other significant issues, yes, the parking and then the AC equipment too.
Right.
Okay,
Okay, so, so let's go there. Woody, why don't you take the lead here and find out what it is about this HVAC equipment
Okay.
and this parking space.
I'll jump in right away
Go
and
ahead.
just
I thought
quickly
Woody
say
might want to ask a specific question.
we
but-
are completely willing to relocate the AC units to the left front of the house, which was one of the locations that Woody had suggested.
Great, okay,
So we're
done.
happy to do
Next.
that. Let's check that off the list and we
Yep.
can move on to the parking.
Let's go.
Okay, we need a separate variance for that. I don't know what the dimension would be from the front property line, but
How do you want to handle that?
We can't lump that into this?
Well, I understand the issue about the variance.
we'd have to do a guesstimate of what the dimension is and figure it out later if the board's comfortable.
Well, I'll tell you what I am comfortable with is if you just handle this administratively, moving that in AC equipment. And if you see some
Yeah, we can-
magnitude of issue or issues, then let me know and we'll chat about it. In the meantime, Mark,
In the front or
Okay.
not around?
okay?
Yeah, we were saying front,
Okay.
left of the stoop.
Woody,
Okay.
Lieutenant, here, let me
We can figure it
stop
out.
here. Maybe this is the solution, because we're already asking for this variance at this corner of the house. Why, and because the AC units would be placed along here and thus farther than those dimensions.
A little bit, but we'll
maybe
figure
we-
it out, okay.
Maybe we just use those dimensions as the,
Or we'll guess 26.
Are you getting new units?
Okay.
Are you getting like decibel,
Yes.
reduced decibel?
oh, yeah,
Okay.
yeah, yeah.
Okay.
Good.
Yeah, there's currently none.
Oh, got it. Okay, that's good.
Right.
Okay.
Okay, all right, so we're good here.
Okay.
Okay, we're good.
And what about the
So-
parking?
So,
Okay, so now we talk, I guess we can talk about the parking.
Okay.
So yes, ultimately what's happening is as part of the additional finished space in the basement, we're losing a garage space and we're asking for a variance to put one of those spaces in the driveway. And thus less conforming with the required setback than currently exists. So we're asking to increase that nonconformity.
I'm sorry, can you say that again? Not the whole thing, just, I understand the part about the garage becoming a part of the basement, I get that. But you're moving the parking space into the driveway, is that what?
Does it work? How so?
No, I said what, I didn't say
Well,
what.
I mean, here's an
Just explain it to
example.
me.
Here's two cars parked in the driveway.
Yeah.
This garage bay here would be the one that would be lost.
Okay.
And so the car that would normally be able to park in there
Yeah.
would be parked where this car is.
They can do that anyway. They can do whatever they want.
My
with their
question was, why is this, why are we,
Why is that up to us?
is that not allowed?
Oh, I have
I'm
that.
trying to figure it out.
So for this size of house, we have to have a two-car
Well,
garage?
we have a regulation that requires 2 parking
I have it
spaces
here.
and meet setback. And if you reduce that.
That was one
nonconformity
that was one that Sarah sent.
So the issue is that this parking, what they're gonna define as the parking spot going forward, not the garage, but where that car is currently, you're saying that's in the setback and that you're not allowing that, or that's not allowed to count?
It's a
Or it's
change.
increasing the nonconformity?
Right, it's
Okay.
changed.
Because what it's doing is, right now, the 2 legal parking spots are in the garage, they're not in the setback. One of them, the garage is gone, so one of the parking spots are
Yeah,
now.
There's 2
Got it.
parking
But that's
spots, but they're already
practically-
over, there is, they're already
Here's
non-conforming
two
parking
photos, two
spots
different
anyways.
photos.
Yeah.
That's where the parking.
That,
Right,
demonstrate that 3
Yeah,
cars
okay.
can park across.
Yeah.
Can we make them get a scooter or something?
They can fit 3 cars anyhow. I understand the issue.
Yeah.
And as far as we know, that garage is filled with lawnmower cutting equipment, and
they
they don't
never
use it
park in there.
anyway.
Never used it, they've never used it.
No one in
for
Connecticut
parking.
uses their garage.
Yeah.
Why? Hold on.
But they do have
Okay.
room for 3 cars.
Yeah, I can see that.
Yeah,
Okay.
that's by the photos.
Okay.
All right. Board have any questions on this? Okay. Okay.
Neighbor support?
There's still a lot of people
There
here.
was
I don't.
8 letters
We
of
have all
support.
supporters here.
All supporters, all right.
Wow.
8 letters of support were submitted, so, kind of gives you a little more of a comfortable feeling that probably nobody's going to appeal.
Yeah, well, somebody's serving pizza
Including the
later, that's all I know.
Including the neighbor that's directly next to
Okay.
them.
I'm sorry?
Including the neighbor that's directly
They
next to
want
them. That was
Oh, yes.
directly obstructed.
Yes, in fact, before we close our presentation or anything, we'd like to have Sarah get up and give you a little bit of the history here and why this is so important to them and what this property means to their family.
Yeah, I'm good on that. No offense, ma'am, but
It's just, yeah.
we're understanding the application, we're understanding the minimum adjustment necessary, and we're understanding the hardship, so we're good.
There's a long family history too, is part of what it is. It's been
And
in
we
the family
appreciate
for a
that
long
greatly,
time.
but honestly, it's not going to impact our decision.
Okay.
Which I think, given what we've heard to this point, we're ready to move on and close the hearing, unless there's anybody of these supporters that would like to speak this evening, but we appreciate your attendance, and we understand you. Next time, bring pom-poms. Okay, so I'm good. Everybody else good?
Yep.
Good.
Okay, all right, this hearing's closed.
You still have to vote.
Yeah. And listen, we are
We'll
going
let you speak and then.
to deliberate this evening, but you're welcome to stay, but you may not make any further public comment. And if you'd like to leave, or if you have to leave, whatever, you can call the office tomorrow and find out what our decision was. Okay? Great. Where are we starting?
Where's the last number?
Oh, God, it's getting late. I apologize.
I know, we gotta hustle.
Yeah,
come on.
okay, sorry. I'm not even done yet. Sorry. Calendar number 9, 2023. The application of Thomas Stolzer on behalf of Dana Massey and Todd Pekala for the property known as 55 Andrews Drive. I apologize, Mr. Stolzer. I was getting ahead of myself. A little wishful thinking, but please, sir,
We'll
the
try to make
floor
this-
is yours.
Try to make this quick. So Tom Stalzer from Stalzer Design Architects. I represent my clients, the homeowners Dina Massey and Todd Bacala, who are here tonight. We're requesting to allow the existing deck and stair to remain with a setback of 34.2 feet setback, not 32.4. That was a typo from the surveyor. It's been updated in the certified survey. A little history on this project. I start every project with a project clarity report where I go in-depth research with town hall, dig up any kind of hurdles, red flags that potentially happen in the design before we start a design. We went through the process of design, construction documents, bidding process, permit submission got denied by Hervé because of an existing nonconformity, which was a big surprise to us.
I'm sorry, I was writing down a question, but I think you might have just answered it.
There's an existing nonconformity. Is that what you're saying? I'm sorry.
So Harvey noticed an existing nonconformity, and that's how he noticed the stairs?
I'm not sure how he noticed it, because my research I had done months earlier, I have a CO for the deck, issued in 2011.
Right.
I don't know how he noticed it, except that what he told me was that he doesn't want to make that decision moving forward.
Well, how did this whole thing come to light? I mean, how did he know that these steps were 3 or 4 feet into the setback? How did he even know that?
Based on my research, it seems like the previous homeowner had been difficult to work with doing pergolas and work without permits, that it was probably a property that was red flagged by the town.
Okay, all right, move on. Sorry.
There's some evidence in files about, I think this guy's doing some stuff without a permit.
Okay.
For tax purposes.
I understand.
So he didn't want to give the approval, even though I had a CO for the deck. He wanted to give this board the opportunity to make that decision. in further research with this deck, there was a ZBA request back in 2011 for not only this deck, but a pergola that was built on the side of the property. They went ahead and approved the relocation of the pergola with as-of-right location. And I guess there was some confusion about dimensions to the deck back at the time. And there was a board member who made a comment during the ZBA meeting that said, the ZBA determined that they could not approve the requested variance for the deck because it is incomplete. However, the members indicated that a new application with the updated dimensions to include stairs would be seriously reconsidered in a new application. So we're in that process now of getting that new application reviewed and approved. We have it's in the file, I think, but we have a letter from a neighbor just north of this property with no objection to the deck to remain as is.
So you weren't seeking approval to build anything new, you're just seeking to legalize what is currently there, and that's been flagged?
Yeah, so what happens is when I applied for the permit for the interior renovations,
Oh, okay.
they would not give us a permit unless the existing nonconformity was addressed. So we requested with Mr. Ginsburg if we can combine these two in one, because, I mean, I'll say it sort of quickly, we were stuck with all this whole process. We'd over-designed and the project came in over budget during COVID, and we scaled down, we got to this process and hit this brick wall. The client only had a small window of time to move out of the house to get construction done, so we agreed that we'll combine it into one and then address this in this format with ZBA.
Okay.
So if we don't approve this, you can't move forward with anything else?
No, we won't be able to get a CO unless we chopped off the corner of this deck,
Oh, okay.
which,
After you complete your interior renovations?
right.
Yeah.
Okay.
So even to get
You
a
have
building
the CO.
Because you
permit.
have a CO already.
He's got the building.
I have a CO for the deck, yeah,
He's
that's,
got the CO for the
But he's not gonna get the CO for the
but
internal.
he's not gonna get a
Okay.
building permit for the internal.
I thought you already had the building
no,
permit.
they did give us a permit for it. He allowed us to combine the deck with the interior.
Oh, he did
renovation,
allow,
yes.
okay, I'm sorry.
Yes, no, we're about
I
80% done
okay,
with.
I got it
that
now.
Okay.
Okay, well, look. Board
This-
member comment, please, and questions.
But we think that CO was mistakenly issued?
Well, the history of it is that the project was approved in 2011 from a building inspector perspective. In 2016, less than 30 days before closing, the CO was issued for a 2011 inspection, so whether it's wrong or mistaken or just to clean up some paperwork, I don't know.
Okay, all right. We got a lot of assuming going on tonight.
Okay.
It is what it is. Okay. Woody, anything from you?
No, not really.
Okay,
No.
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 okay. I think we're good, unless there's anybody that, from the audience, who'd like to talk to me about stairs. Okay, great. This hearing is closed.
Thank you.
Okay, I'm not gonna repeat the whole diatribe we went through before, because now we're gonna deliberate, so you know what we're gonna do. Where are we starting?
Okay, you took my schedule.
Can I suggest we start with their stuff?
Yeah, you want to get the easy one?
Yeah,
Get
Sure.
these guys,
I love
these
that.
guys
Great
out of
call.
here.
All right.
Understood, the easy stuff.
I approve.
Go
Oh, wait,
right.
sorry, wait, one, all right, okay.
Reverse order out of here.
Yeah, okay, yeah, I'm down for that. I shouldn't say that way.
Last in, first out.
That works for me.
Okay.
Okay, so
55 Andrews.
this is 55 Andrews. I mean, anybody have any comment on this?
No, I'm just gonna go with it.
No, I'll keep my mouth shut.
Thank you, Kevin. All right, I'll make a motion to approve.
Yeah, we're not, may I have a second?
Second.
Great, all in favor?
Done. Well
Done.
All right.
Good night, sir. Thank you for coming.
Thank you for being honest about it and
Yeah.
coming in. Not that you had a choice, but that was
Okay.
nice.
No,
Okay.
no, we should do that next.
Yeah.
Oh,
Raymond
okay,
Street.
real reverse order, okay?
Raymond
Reverse,
Street.
Raymond Street. Comments, questions, and concerns?
Well, it's clear there's something unique about the property, that there's only 30 square feet of building space, and that it's a triple corner front yard lot. It's clear that that has created a hardship in what they can build. It's clear to me that 1,950 square feet feels like the minimal adjustment. I have no issue with that. I don't have any issue with the driveway. I think that's a technical issue. It still feels like a minimum adjustment. The only question is the fence, and I don't feel strongly. I defer to you guys in the town about what you want to do about the fence.
I don't feel strongly about the fence either.
I don't either.
I like what Kevin said.
And the ACs are
Yeah, the ACs are gonna be
Away
worked
from
through
the neighbor.
staff, yeah, work through Woody and and if either party has any issue, well, Woody will call me and they'll have to refile or something, but I'm sure they can work it out.
Yes.
Okay, do I have a motion? Do I have a second?
I second.
All in favor?
Well,
Whoops, what did?
but the motion is to approve, subject to figuring out the AC placement administratively.
Yeah.
Effectively, you'd be denying the requested AC variance numbers, but we'd find another spot, so I think it can be a stipulation.
Or you can leave that stipulation to staff will decide.
And I can assure you, staff's gonna deal with this fence.
That's not our issue. We,
Yeah,
the
no.
Do it
board,
that way.
the board,
Okay.
that's not, we've got nothing to do with
We're
that.
passing this on.
Yeah, we pass it. What's next?
Congratulations. Okay.
So
Yeah.
yes.
Oh, so yes, so
I'll
yeah.
vote yes.
So yeah. It is getting late.
And by the way, appreciate how grateful we must be to have neighbors that will stay here until 10 o'clock.
And we love Canopy Builders. We love EPI. Yeah, yeah.
Interesting.
Now we're going to talk about neighbors who hate each other.
Oh, that's on TV.
Wow. Okay, you want to go
Not
to
hate.
5 Mile River first and then?
102? Yeah, who's?
Bye, guys.
Bye, guys. Look at all the people that came for this. I've never seen that before.
That's awesome.
Okay, 102 5 Mile.
Can you leave that open? Is that all right?
Yeah.
No, leave it
Get some
open.
air.
Open.
No, can you keep it open? Yeah, it needs
It's got
some
warming.
air in
Yeah.
here.
All right.
Okay.
102. This is the same exact application. I don't even know why they're here. Who's got a problem with this?
I don't. Nothing's changed. The neighbor updates were current within the last few months. I'm fine with it.
Yeah, I mean, the one thing I would say is, I'm not quite 100% bought in on that it's truly unique, or that this is necessarily the minimum adjustment necessary, but I defer to a previous board
I kind of agree.
who had heard a full presentation on this and made a full determination, so I'm fine.
Including chair.
Yeah, and you know, Gary was on
disagreed
this, and
before.
Gary is like a stickler for minimum adjustment the first
Yeah,
time around.
actually, he was.
So Kevin, I gotta thank
Mike
you.
and
He was
Dan,
hard
too.
on it, but I love your comment. I do.
Yeah.
Good.
Okay, great.
Okay, so we have a motion to approve? You want,
Do I have a motion to approve?
I'll motion.
And second?
do it.
Perfect, all in favor? Great, there's
Okay.
5-0.
Okay.
All
This
right.
one, long neck.
Okay.
Jesus, the long, long neck. Okay.
Okay.
How can these neighbors be doing this to each other? This is just,
It's about the trees.
Of
Yeah.
course it's about the
The view.
It's
trees.
about the trees and the view. I mean, if you look at what the view looks like, they had that one, they only really had a sliver.
that one little slice, yeah.
And they got taken away because of the
Yeah.
trees. Now, the pool has nothing to do with it because you can't even see the pool from the
It was just the
property.
prompt for doing the privacy.
Yeah, Gold can't even see the pool from her
I
window.
know.
So,
I mean, if the applicants or whoever is listening to this record, it seems to be both sides have lawyers. Whatever we determine, there's a good chance there's some
Okay.
appeal from it.
Yeah.
And maybe the parties would be wise to save everybody a lot of money and trouble and come to some compromise and some reduction in the trees in exchange for dropping the appeal or something. Seems
They
like
said
would be
they've
a
already
solution.
done it. Now they're gonna go back and.
Well, it seems
come
like they
back.
just moved them, but there's still a whole wall of them.
Yeah,
Maybe
there is a
something,
whole
I don't know,
wall.
but whatever, that's
I
not
agree
for
with you.
us.
I would encourage them to work with each other.
And by the way, I never really got an answer to the question of why can't the Swillers just move the pool? I mean, why did they move? It wasn't
was
their.
previously
I
back
know.
there.
So why did it get moved?
I think it's pretty tight, like all the houses they have in front and back, there's a lot of.
So maybe then some compromise could be had between
Right.
them, but that's not for us to figure out.
It's not. So we leave it to the parties to hopefully get a peaceful and an amicable resolution to this issue. But I'm not seeing it as a zoning board of appeals issue right at this moment, unless anybody has any other particular comments and thoughts?
Yeah, I mean, I think we should talk through a little bit the
Okay.
specific
Yep,
claims.
sure,
but
please.
Restating now with everybody here, seems to me if there's gonna be appeals of this, it would make sense to try to come to some compromise with some reduction in trees to drop an appeal, but you're not allowed to present on this, but it would, I suspect you're gonna say, the parties have tried, but whatever. So my view is there's two issues, right? The timeliness of the appeal, and then the bigger question about whether we can enforce this private regulation. So on the timeliness, I don't know how to make a judgment between
It's so
the two
close.
parties, specifically one by affidavit, one by testimony here, disputing that they had this conversation. I would tend to lean a little bit more towards a sworn affidavit with a lot of specificity versus the general statement about not remembering the conversation happening. As to the merits itself, I agree wholeheartedly with the person opposing the appeal that this is a restriction between two private parties, and the zoning board of appeals should not be affected by a private agreement, nor should it affect a private agreement. And we are not in the business of looking to see what agreements are between private parties and enforcing those in any way. We make our own determinations about zoning and what's appropriate for the town, regardless of that. But the argument is a little more nuanced than that, which is when the subdivision was approved, a map was attached to that approval, and the documents that approved it did say that the plan is a binding part of the agreement, and it did cite various intents of the committee then to protect the coastline and to restrict development, et cetera. So I think there is a real argument there, and it's not anywhere nearly as clear-cut as one of the sides was arguing, but it is compelling to me that on those plans that were attached to the approval that were binding, there is no specific reference to what it means that there is a restricted development line. That line is on the plans, but there's no detail about it. There are multiple other parts of those restrictions that are detailed in terms of the easements, et cetera. So while I think it's a fairly close call, in my assessment, when the town approved that subdivision, it did not, when you look at the totality of the record, which we do under the court case that was cited, we look at the totality of the record, I think the absence of detail about what that restrictive line meant is, for me, ultimately compelling to the point that this was not a restriction specifically adopted by the town, that this is a private agreement between the parties, and it never progressed to the town making it a legally binding restriction that we could in fact enforce. So I'm inclined to reject the appeal, not because it's timely, because I can't really make a judgment on that, but because ultimately this private agreement by the parties was, I don't have sufficient evidence to say it was adopted by the town as a restriction on the land.
What he said.
Kevin, you mentioned that you didn't think the ZBA had authority, how'd you put it,
For a private agreement.
should not enforce this restriction. Would you say the ZEO should not enforce that
Correct.
restriction?
I don't think the town government has any business whatsoever enforcing a restrictive declaration between two private parties, but I do think it has the authority to enforce that if such restriction was made a condition to an approval given by the town. And while there's some evidence pointing at that possibility, we never really closed the full loop, because there's no, while the plan has the line, there's no detail on what that line means. So I don't think we can take that next logical step and say that was a requirement adopted by the town, because there was no real meat around the bones about what that was.
I think it's too assumptive.
It
We're
would
drawing
be,
an assumption.
it'd be another yet assumption.
Which, I agree, if those notes had explained in detail what the restrictive lines were, that would have made the argument for me. I'm sympathetic to this problem. This is really sad, that this is taking up so much time and energy.
Yeah. John, Matt, comment?
Yeah, I
Question?
mean, I wish that this, from 1982, this ruling had more information in it, you know, specifically referencing some of these lines and whatever else may not have been discussed, but I agree with Kevin, just, there's not enough there.
Similar sentiments. I'm sympathetic to the change in the skyline and the view and how now the Gold's property's been impacted by this. But I don't think that has a whole lot to do with where the pool is located. So from a standing perspective, I'm not sure that the position of the pool it's the trees that really caused the issue. So I think that should be dealt with separately. It has nothing to do with where the pool's located. And
Well, as Kevin said prior to the parties coming back in the room, that, you know, he hopes, I don't mean to speak for you, I'm just trying to repeat, you know, we all hope, I should say, I shouldn't be specific, Kevin, we all hope that they can come to some, you know, amicable resolution with regard to the trees, and both parties are satisfied in the end, but, you know, we'll leave that to them. And as I said, when Kevin finished his rather eloquent explanation, you know, what he said, I'm in total agreement. Barb?
I agree as well.
Okay. I don't think there's much more that we can say at this point unless anybody has anything else. Okay, now, this is a denial, is that correct? We're denying.
Right, we're moving to deny the appeal.
Okay, it's a straight denial, is that, I'm right? So,
I think we should create a record, though, of the basis.
Yeah,
Sorry.
for lack of jurisdiction by the CEO, or for the timeliness, or
Yes, so
both, neither.
My perspective on it is that I don't think we have sufficient evidence to reject it based on timeliness.
Right.
So I would move that we reject it based on the applicant is seeking, sorry, let me rephrase. The ZEO officer was right in his determination that ultimately this was a restrictive declaration between two private parties, and it was not a restriction adopted by the town as part of the subdivision plan, and therefore he was correct in rejecting. Right, because isn't that ultimately happened? The ZEO officer rejected an application.
Well, the
No.
CEO approved
He
the
approved.
pool permit.
Right.
And
So
where
he was,
it's
so he
located,
was,
that about.
he was within his authority to approve the permit because the restrictive declaration is between two private parties, and it never progressed to a binding I would say, to a binding condition of the approval of the subdivision in 1982.
Thank you, Kevin.
Okay.
Sorry, I struggled there at the end.
No, that's perfectly okay.
beautiful.
So I
Did
would
much
move
better
to-
than I.
So we moved to deny the appeal, based on those reasons.
Do you want to make a motion?
Yes, I move to deny it.
Okay,
Do I have a second?
I'll second it.
Okay, I'm in favor of the denial, okay? So,
Okay,
5-0 in favor of denial. I think I got that out right, okay? All right, I'm gonna quickly do other business. Thank you, everybody, have a nice evening. And are you gonna tell me that you came to an agreement in the hallway, or what? I hope you do.
Okay.
That's what I like to hear.
Thank you.
No problem. No, and thank you for your argument.
Can I ask
Thank you.
you?
We approved it.
We're always looking for board members.
Yeah, we have much more fun over here. Okay, so other business, Woody, where am I? Where am I?
Well, maybe the March 15 minutes.
We approved those earlier today.
Yeah, so everybody good, everybody see the March 15th minutes? Everybody good? Do I have a motion?
I was on those, so I'll make a motion to approve.
I'll second.
Okay.
No, Matt second.
Matt seconds.
All in favor?
Aye.
Done. Is there anything else that's urgent? No. Okay, good.
I'll do a historical update next time if you want to put me on there.
Excuse me.
I'm waiting for town council to weigh in.
Pardon me. So may I have a motion to adjourn?
Make a motion.
And a second?
Second.
Thank you, and this meeting is.
Nice work.